Mention bail petition number 34 of 2024. Madam, I want to withdraw this bail.
Which one? Item?
Unlisted item. Unlisted item. Madam, this matter may be released for tomorrow
Why?
for withdrawal.
Supplementary.
No, madam, unlisted item.
May I please, my lord,
Yes.
to mention item number 5, my
Why?
lord, on behalf of M. Kato, my lord.
Yes.
My lord, due to some personal difficulties, he is out of station, my lord. Therefore, matter may be released after vacation, my lord, and take consent from the
On
other
the
party.
prayer of Mr.
And Sora,
Sora M.
and Sora.
N. Sora, learned counsel,
Right.
appearing on behalf of Mr. M. Kato, learned counsel for the applicant. List this matter after summer vacation.
And my lord, item number 8 and 9, my lord. On behalf of M. Kato, here he is respondent, my lord, and take consent from the petitioner, my lord.
Then Mr. N. Sora, learned counsel, appearing on behalf of Mr. M. Kato, learned the SGI, DSGI, with the consent of the counsel for the petitioner. Press for listing the matter after
All 22 July.
after 4 weeks. List after list according.
Development.
Interim order personal yes.
May I lordship.
Yes,
Also, I beg to mention item number 7.
yes.
Yeah, parties are negotiating outside the court. So, one more time may be given.
What is this? Washing? And
Yes. Passing,
who is for the other side?
pardon, lordship.
Who is for the other side?
K. Lolan, sir.
You have
Yeah, taken the
taken
consent.
MS. So and so, learned counsel, appearing for respondent, petitioner.
I'm for the petition.
Petitioner submits that the parties are making an endeavor to settle the matter outside the court.
Lord,
She prays for
fix on 22.
this for listing the matter on
22, 7, 24.
22/07/2020. Praise the Lord. No, considering the above, come on, list this matter on so and so, then.
What's your blessing?
Lordship, I would like to mention item number 24 and 25.
20,
24 and 25.
why?
Lordship, Mr. El Fermi, the leading counsel is absent due to some personal reason.
25. Right, this has been fixed.
Lordship, we have taken the consent from the other party.
Doesn't matter. We'll see, you be there. You give him the file, second file. You take the second file. You take the second file and read it.
Item number 2.
May I please, Lordship? My lord, I beg to mention item number 6,
Yes,
where on behalf of petitioner, the leading counsel is out of session due to some his personal difficulties.
you are for
Petitioner, appearing on behalf of Mr. K. Tama, the leading counsel.
Mr.
K. Tama,
You,
K. Ube.
Mr. K. Ube, learned counsel appearing on behalf of Mr. K. Tama, learned counsel for the petitioner. Submits that the leading counsel,
Your
Mr.
Lordship.
K. Tama,
It may be fixed on 26th of
has
June.
no personal difficulty.
We have taken the
Therefore,
consent of
he
other
prays
parties also.
listing the matter after 2 weeks.
26th June, sir.
26 of what?
June, this month, sir. We have taken the consent also, sir. And
Yes,
meantime,
this matter on 26/07/06/2020.
Your Lordship, meantime, there is an interim order here. It may be continued.
Interim order person.
Please.
Your Lordship, I beg to mention item number 11.
Hmm.
Your Lordship, I'm on behalf of Titaba. We are for petitioner. Lordship, the learned council is out of station. Kindly matter may be fixed after 2 weeks.
On the prayer of learned council for the learned council. Mr. Titaba. On the prayer made on behalf of Mr. Learned council, Mr. P. Taba. And council for the president. This is better after 4 weeks. Yes.
My lord, I would like to mention item number 2. The conduct-
Item number?
Item number 2. Conducting council is on leave. on
Huh?
health ground. Conducting council for the petitioner is on leave for health ground.
You take the. No adjournment. Give the second file. You read the second file, we'll dispose it off.
My pleasure, your lordship.
Yes,
In item number 15 and 16,
15 and 16.
yes, I have filed affidavit in reply today.
Yes.
That may be called for from the registry.
Okay. Affidavit,
May I
15 and 16.
Yes, may I beg to mention lordship, item number 12. this
12.
Lokam Tala matter. Lordship,
Yes.
On the last occasion, also, on the request of my there's a friend, I have mentioned this matter for 2 weeks. But without fixing, he's a out-station lawyer. Without fixing the particular date, he is unable to come. The matter, all of a sudden come and he could not, he was not ready. Particular.
On the prayer of on the joint prayer of London Council for the.
I am objecting. Since 2018 matter. This is.
Which one? Item
Item 12,
12.
yes, item 12.
Item 12 is not, it's 2024 matter.
No, it's
2024.
appeal. Check bounce case,
Huh?
NI case.
Item 12 is 2024 matter.
Yes, 24.
No, appeal was filed on 2024.
Then,
New matter. Before this court, it is new.
okay,
Case was going on before the law court.
what is the matter?
Because check bounce case.
Okay, so
CGM,
what is to be done today?
Uh,
Just sir, tell us.
Maybe.
not
court-
that fixed date may be given.
Maybe
Okay.
matter may be fixed on 26th of this month.
On the prayer of Mr. D. Tapak, another
26.
council for the respondent petitioner,
Yes, petitioner,
another council appearing on behalf of Mr. S.K. Das,
not Manojit. Swas.
M. Biswas, another council for the petitioner. Submits that since the leading council in this matter is from outside the state. Particular date may be fixed. Accordingly, he pressed for listing the matter on 26/06/2026.
And this may be last time.
Mr.
If we don't
Peter,
have-
London Council for the respondent has opposed the adjournment of the matter. However, considering that the London Council is from outside the state government, the last sense is afforded to the London Council for the petition. In view of this matter on 26/6/2020.
Interim order is there, that may be.
Interim order person, yes. Sir. Yes,
Lordship, I beg to mention item number 14.
14.
Lordship, inadvertently, I could not.
On the
see-
prayer of Mr. K. Lawler, the council to the petitioner. No problem. And not being
on Tuesday, Lord.
and the prayer not being opposed by Mr. Titi Tara, the council for the respondent. List this matter after 4 weeks.
On Tuesday, Lord.
Tuesday. 18.
Deeply obliged.
Is that from this supplementary? This supplementary course list. We'll take up supplementary course list. We'll take up the supplementary course list first. Sir, we'll take up this motion matter. Heard Mr. Titi Tara, learned counsel for the petitioner. Applicant. What is the offense?
Section 6(8).
POCSO, Your Lordship.
Applicant. Next para.
Your Lordship, I have objection on the impleadment of the victim, non-impleadment of the victim, Your Lordship.
You plead.
My lord, if that be the case, so I have the notification which says the guardian. What the High Court notification number 17 is there. I was aware of this, because objection is likely to come. If the guardian is there, guardian is the CWC now, under their custody, and even in terms of 2018 amendment, it is very clear.
But
And
the-
pursuant to this guideline, this Anoki Lal, that Jagjit Singh judgment, which I always gives my opinion that is a bad law.
It's not a bad law. In Jagdish Singh,
Yes,
it recognizes the participatory right.
participatory right only. my lord.
So far,
But
the
that one is the best
implement is concerned, we have the division bench judgment.
Yes.
Deepak Nayak case, Your Lordship.
Deepak Naik case is
Deepak
there.
Naik case is there,
Do
but
you have
now
that?
this notification we have.
No. Do you have the Deepak Naik?
I don't
Deepak
have.
Naik is very clear.
Very clear.
Offences arises out of
POCSO.
POCSO as well as the offences covered under 439 1A. That's all. Last two days back, I have
I heard about it. I learned about
I've disposed of.
it.
I have decided the matter.
Yes.
If it is involved, implement is mandatory. POCSO as well as the offences under covered by 439 1A.
Yeah,
If it's a
439
POCSO, you have to implement.
And this is this notification also says so. It says
See, it's of which notification?
High Court notification,
Which year?
24 March.
Marston?
Yes.
That's maybe after the Deepak Nayak only.
Yes, after Deepak Nayak case.
I anticipated that this is a favorable ground for the TPs to make objections. Then I thought.
This is the procedure part, Your Lordship. This is not a substantial objection on material, Your Lordship.
Is he a support person?
Yes, my lord.
Abazin, chairperson, Child Welfare Committee, Itanagar.
Yes, and they are under our custody now.
Your Lordship, the issue here is, Your Lordship, if as per the Deepak Nayak judgment, Your Lordship, it says the implement of victim guardian. It doesn't say, Your Lordship, if guardian is implemented, then implement of victim is not required. It doesn't say so, Your Lordship. If victim authorize the this child welfare committee to appear on their behalf,
Issue notice call for the city will decide on this issue. It says oblique slash.
yes, Your Lordship. But Your Lordship, whether they are come under the definition of guardian or not, Your Lordship.
No, support system, support person. The victim is under this respond number 2.
That we don't know, Your Lordship, as on that.
See, respondent number 2.
Yes, that it's, but
Chairperson,
he has been implemented personally, Your Lordship.
Child Welfare Committee.
She has been implemented in person, Your Lordship.
Yes.
In person, Your Lordship. Not the child welfare committee represented by.
Anyway, I will not go into all this thing.
Well, that.
We'll decide this on the
Yes.
next.
Yes, Your Lordship.
Even that.
I heard Mr. Titi Tara, learned counsel for the applicant. Well, this is the next one. This is an application under section 439 of
right.
CRPC, 1973. For the praying for grant of post-arrest bail to accused Shri Balung Marik in connection with Itanagar WPS case number 20 of 2024 under section 373, huh? Because that delivered, huh? I mean, in the who has been arrested on 14/05/2024.
Eh?
A call for the second copy of the case.
I take usual course also.
The petitioner, the land council will petitioner to take steps for submission of notice upon response number. Where is supposed to be? Mr. Within 2 days. Within 2 days.
Yeah.
Mr. T at the learned additional PP appears for the state. Mr. Next paragraph. The next paragraph, Mr. T at learned additional PP has raised an objection that in cases in the offense, in the cases involving the offenses under section, under FOXO Act, the victim is to be implemented in view of the order of this court, and the division bench of this court in the case of Deepak Nayak. However, Mr. Titi Tara Leonard, no, please, not however. To that, on such objection, Mr. Titi Tara Leonard, counsel for the petitioner, applicant, submits that since one advocate Taba Jim, chairperson Child Welfare Committee, has already been implemented as respondent number 2. The implement of victim is not necessary. He referred to the notification.
Well, instead of
Notification number 17, dated 15/03/2024. Of the Guwahati High Court submits that the implement in the bail application is to the victim or guardian or support person. In the present case, since the support person,
this is oral.
namely the support person has been implemented, there is no requirement of separately implementing the victim. So having considered about the objection raised by the learned addition PP shall be determined on the next date fixed.
Well, this is
List after list
19.
19. List on 19.
One thing.
19,
before my lord,
06,
party
19.
the records. One thing I want to make suggestions. If the manner how the alleged accused persons are arrested by the investigating agencies, even my lord, including myself, all of us will have to deactivate the online transactions. It is something, all of us have to deactivate
In connection with this matter.
Yes, Lord.
Anyway, we'll see.
Very dangerous.
We'll see. But then I think prime facie, I'm of the view that this, if that support person is, if they can say that if it's a support person,
We have to read the section 40 of the POXO Act. It
Yes.
says, in case if they are not in the position to take legal, to represent themselves, then legal assistance come, Your Lordship. We have to
it's
read.
not a
and-
legal assistant, support person.
Yes, Your Lordship, basing on that, the judgment has been pronounced Deepak Nayak case, and Your Lordship, its slash has been used. Meaning thereby, Your Lordship, it doesn't say or. It says everyone, if the support person is also there, they have to be implemented.
No.
And
No, I'm sorry.
Your Lordship, if
We'll consider.
and moreover, Your Lordship, the chairperson has been implemented in person, Your Lordship.
19.
It will
We'll
not
decide.
Serve.
Oblige, your lordship.
No one appears for the petitioner. Next para, this is an application under section 5 of Limitation Act 1963 for praying for condemnation of 31 days delay in filing the connected criminal appeal against the judgment and order dated 01/03/2024 and the sentence dated 11/3/2024 passed by the learned special judge NDPS, West coming, Pakke Kesa, East coming, and Tawang district in NDPS case number 04 of 2023 in Balimo. PS case number 03/07/2022 under section 20B within bracket B, capital Roman, small Roman, to bracket close, bracket C, bracket NDPS Act 1980. The what appears for it? You know, only just issue notice.
Yes, it's a, the IA is pertains to condemnation of delay.
Yes.
Yes.
Do you have any objection?
No objection, your lordship. It's an NDPS case, your lordship. Otherwise, there is no any requirement. It's statutory appeal, yes.
In this case, no issue, huh? In the experience. The grounds of, no, I have, where is the grounds for condemnation of delay? And on it to be on the same learned additional PP for the state has no objection for condemnation of delay. Next point. In view of accordingly, this the delay of 31 days in filing the connected appeal is condoned. Next paragraph. The IA instance disposal, allowed and disposed of. Registry 2. Number the connected criminal appeal.
SIPA in earlier round of litigation, no SIP appear in this case. Yeah, it's
List before any other appropriate bench without. Yes. List before any other appropriate bench. Without. Yes. Correction of date of birth. Correction of date of birth.
Yes.
Yes. Make your submission.
The concern petitioner
You are for?
I'm for the petition.
Then
No, I'm not aware of the.
you give the file, we'll take after
I
some.
read
What you have read? What is your case? Read it. Tell us.
Pertaining to the date of birth which was
Yes,
put in the service book.
yes.
That's the question.
Tell us.
Your Honor, actually,
We have given you the file, same thing, the file which you have a different file or what?
no,
Other than the same petition you will be having in the chamber.
date of birth actually, also represent put wrongly in the service book. It is actually 1978, but they have put 1976 in the service book. By the respondent.
Yours is 1978.
Yes. But in service book, they have put up 1976. Because of which I will be retiring 2 years earlier. For my actual retirement.
Let us see. Where is the service book? What is this, page 15?
Page 15, it is class 10 passer.
Then
Uh,
it is 78.
Service sheet, it is given, yes, Your Honor, actually it is 78, but in the service book, they have wrongly put
76. Okay. Page 14. Transfer certificate.
That is school living certificate, page 14.
Yes, this is 78.
All the documents are 78.
But this is 7, yes. Okay. When did you join the service? All the documents are 78,
Yes,
but it has been wrongly entered as 1976 in the service book.
yes, ma'am.
When did you join this date of birth was entered into service book?
I was appointed as a constable in 1996, and I was 17 years. The advertisement for the constable, it was actually, the qualification was class 8 and age limitation was 17 to 21 years.
When did you make your claim? Only 2017.
Yes.
It has to be made within 5 years
Yes,
after the journey.
limitation is 5 years.
Yes, what to do? In fact, all the certificates are of 1978.
1976, Your Lordship, not 78.
Where?
He has produced the transfer certificate. There only he has, it's 78. Others, Your Lordship, in service book also, Your Lordship.
No, no, forget about book. See, this class 10 certificate.
Your
Page
Lordship,
15.
Class 10, Your Lordship, he has appeared after joining the service, Your Lordship,
Okay,
in 2010, Your Lordship.
okay, then,
During this selection, Your Lordship, he has submitted the attestation form. All the selected candidate has to submit the attestation form, Your Lordship. There he himself has written 1976, Your Lordship. In my affidavit, page 11, Your Lordship. '76, Your Lordship. Medical form also, it's 76. In service sheet also. In all these seniority lists, Your Lordship, it is 76, Your Lordship. He has not corrected it earlier, Your Lordship. Now he is coming after more than 20 years, Your Lordship. In 2017 only, Your Lordship, he has submitted his representation for correction.
where is that OM? So this, except the transfer, certificate,
Yes, Your Lordship.
it is 78.
It is 76.
Rest,
It is 76, Your Lordship.
which one?
His date of birth is 76, except his transfer certificate, Your Lordship.
No, she, page 13 of writ petition.
That is his transfer certificate, Your Lordship. This is not his date of birth, Your Lordship. Date of birth certificate, Your Lordship.
No, no, he's recorded as 9978. Right?
Yes, Your Lordship.
It was issued on 12/1/1996,
1996,
SEPA. And then page 14,
14.
07/10/1996. It's also 78, page 14. Page 14. This transfer certificate. Right?
We cannot consider transfer certificate as a date
No,
of
no,
birth.
just wait.
Yes,
We'll come to that. This also 78.
yes.
Then page 15,
Page 15, Your Lordship. This certificate is of 2011, Your Lordship.
2011.
He has joined the service in 1996, Your Lordship. He was not class 10 pass during that time, Your Lordship.
Okay, so we cannot,
Consider this, Your Lordship.
okay, then,
And if you see at a form, Your Lordship, during the selection which he has submitted, Your Lordship, may kindly see my affidavit, page 11, Your Lordship.
we'll come to your affidavit. Don't worry, we're not running away.
In page 17, read petition, Your Lordship. Here also it's 1976. Final provisional seniority list of,
No, from
Yes,
that only
yes.
he started claiming that it's
Yes.
wrongly been, when he
Yes.
came to know, according to him, he came to know from this financial list
yes,
that it is 1978. According to him,
1976, yes.
76.
Hmm.
Wrongly, it has been entered, and thereafter he, where is this, where is his name?
His
In this,
page 17, serial number 41.
41. Tate Nabam.
Here education qualification is also class 9.
Okay. This is of which year?
It's 2017
2017.
ASI,
Okay.
seniority list of ASI, Your Lordship.
And his 2018, you have considered it?
96.
Rejected his. Then
Rejection is at page 18, Your Lordship,
Yes.
2017.
Yes, now we'll come to your secret affidavit. Yes,
Page 11, Your Lordship.
11.
Yes. At serial number 7, Your Lordship, date of birth 7/7/76.
7/7.
76, Your Lordship.
Hmm.
His signature is there, Your Lordship.
Is filled up by him only.
He has himself has filled up this form, Your Lordship.
Yes. Then,
And medical certificate, Your Lordship, by
yes.
the medical superintendent, page 15, Your Lordship.
Hmm.
Here also it has been certified that last paragraph, his age according to her statement is 19 years and appearance also about 19
Which one?
years.
Which one?
Page 15, Your Lordship.
Page 15.
Certificate by the medical superintendent.
Okay. 19 years. Is here according to her statement,
Yes,
19 years.
yes,
In that case, it is 76.
76. And Your Lordship, the seniority list of constable, Your Lordship,
Yes.
it's at page 53, Your Lordship.
Serial number,
Page 53,
not 53.
page 53. Third from last, Your Lordship, third serial number from last.
1681.
Tate Nabam
1681. Okay. Yes.
is 76, Your Lordship. After constable, Your Lordship, he has been promoted to head constable, Your Lordship.
Yes.
There also, Your Lordship, his date of birth is 76, Your Lordship. Page 72. This is the seniority list of head constable. Page 72, serial number 305.
'72.
Page 72. Page 72.
305.
305, Tate Nabam,
Yes.
76, date of birth.
This is of which year? 2018.
2012.
2012.
Order is at 61 page number. Final seniority list of head constable in civil police, page 61.
Yes.
And after that, Your Lordship,
Is it final or provisional? Given slash.
and after that, that ASI seniority list was issued, Your Lordship,
Hmm.
which he has annexed in his writ petition, Your Lordship.
In
There also,
2017.
yes, Your Lordship, 76, Your Lordship. And in the service sheet also, Your Lordship, I have seen it in his writ petition, page 23, Your Lordship. In his writ petition, page 23,
20.
in his service record, Your Lordship.
Yes.
Your Lordship, his date of birth is 76. His thumb impression is there. His initial is there, Your Lordship. He cannot say that he has not seen this,
So
Your
this
Lordship.
school certificate
Yes, Your Lordship.
is obtained after he,
Yes,
Ye-
Your Lordship.
during his in service
Yes, yes,
from open school.
yes.
So there's no other certificate,
No, that he has produced, Your Lordship.
but you have based on what? On his application form?
Yes,
Any
which
other,
he himself has,
any other
furnished.
documents which you have relied?
no, Your Lordship.
Because this transfer certificate, it shows 76. if you don't have other documents.
Otherwise also, your lordship, it's his responsibility to correct it, your lordship, before
Within-
5 years, your
within-
lordship.
Within 5 years.
Yes.
Yes. What is the office memorandum?
Office memorandum that we have not annexed, your lordship, but that has been mentioned while rejecting his prayer, your lordship. At page 18, your lordship, that has been mentioned.
So the error, only when the seniority list was circulated, only then I came to know about the error. The year 2017.
Where you have made your statement that it's as per the as per the office memorandum, it should be within 5 years.
Yes,
You make, the statement you have made,
yes. Paragraph 9, your lordship.
yes, come to his reply. You read the paragraph 9 first.
Paragraph 9.
Read it.
With regard to the statement made in paragraph 7 of the writ petition, the answering respondent admitted to the extent that the representation of the petitioner dated 21/2/2017 for change alteration of his date of birth was considered by the AIGP PHQ Itanagar as per the OM number so-and-so dated 24/3/2004 issued by the Administrative Reformed and Training Department, Government of Arunachal Pradesh, which provides that alteration of date of birth of government servants should be rectified, corrected within 5 years of his/her entry in government service. As such, the application submitted by the petitioner dated 21/2/2017 was rejected by the AIGP PHQ Itanagar by office memorandum dated 8/3/2017. As regards his contention that entry of his date of birth as 7/7/1976 in his service book was unknown to him till circulation of seniority list of ASI on 3/11/2017 is totally false and without being there any truth therein. His date of
Because
birth-
there was a seniority list in 2012 also.
Yes,
Head
your lordship,
constable.
yes.
Then
And constable 2007, your lord, 4, your lordship.
four
So
also.
all these are there, your lordship.
And then what is your, it should be within, if it's, in case, if really it's a bona fide mistake, or if it's really your age is wrongly been entered in the service book, within 5 years as well the office memorandum. Your reply is page, para 9. You read that. You have immediately to reply to this. In your reply affidavit.
With the petitioner state in response to his second representation, the respondent authority, that is Superintendent of Police, Papumpara District.
No. Paragraph 9 of your reply. Reply to the affidavit in opposition. Last. Your reply. Just show it. Last. In the last. Must be in the last.
as regard to the statement made in para 9 of the affidavit in opposition, the deponent state that same plea has been taken by the respondent. Hence, no need to explain in detail. Being known consideration of his representation, the instant case has been filed questioning the validity and legality of the order, which should not been rejected.
Your
So
Lordship.
you evade to reply. You refuse to reply.
Your Lordship, I would like to rely on judgment, Your Lordship.
Let it say.
Your Lordship, it's regarding notification within 5 year, Lordship, for correction of paragraph 8, 11, and 13, Your Lordship. Paragraph 11, Your Lordship.
Thirteen.
13 also, Your Lordship.
This is the notification. Is parameter with your notification of 2004. This is the notification of Government of Maharashtra.
Yes, Your Lordship.
Is it parameter?
Yes, it's also administrative, Your Lordship.
Because you
And also delay and
you have a
lectures, Your
different
Lordship.
notification.
Yes,
But the same.
yes,
5 years.
5 years, Your Lordship.
Okay. So, sir, we're dismissing your writ petition. See, I'll tell you, you have joined your service in year 1996, right? As a constable. Then, with all those, you have fill up the form indicating that your date of birth is 07/07/1996. And then 1976.
1978.
And then there was a seniority list in 2004 for constable. And then 2012 head constable. And 2017 or 18 for assistant sub inspector. Now you are claiming that you came to know only in 2017 when this last seniority list was published. It is hard to believe because before that, before your promotion to the post of ASI, there are 2 seniority lists for constable or head constable. You did not object. And you have obtained your class 10 certificate of you passed your class 10 via open school in 2011, which shows 1978. Of course, you have a transfer certificate, school living certificate, which shows that 1978. But as per the office memorandum of the state, normally it should be within 2 years, 1 to 2 years. But in certain cases, if there's really a bona fide mistake, then it should be within 5 years. From 1996, you started claiming in 2017. How many years?
More than 20 years.
20 years. It's not permissible. Genuinely, you may have been born on 1978. But then law doesn't support you. And your explanation sought to be made is hard to believe. So who is your senior?
C. Modi.
We'll formally hear him tomorrow. We're dismissing the writ petition. All right. If he wants to improve something, we'll hear him for 5 minutes
Lordship.
tomorrow. Or Mr.
W. Kumra.
Huh?
W. Kumra.
W.
Kumra.
Kumra,
AHO
council for the petition. And also had MS Arbas, the state council for the state response. Mr. uh, let the matter be fixed on 13/06/2024. So as to enable Mr. C. Modi to make his submission, although this court has heard Mr. W. Kumra in detail. There's nothing much. You discuss with your senior in the evening and let him argue. We'll dispose it of tomorrow.
Please, Lordship.
Yes.
One of these repetitions, I have made an attempt to invoke the principles of equal pay for equal work for that limited period where we have worked as headmaster. My lord, before I go into the brief on the facts, the question involved here will be that the government says I was appointed as in charge headmaster, and some persons who were in fact junior to me were appointed on officiating basis. We are all are same. All were not eligible for promotion.
They have been reverted back.
Yes,
They are no longer there.
they have reverted back. Now my only claim is from the date when I was given this responsibility and till the date of reversion when I have acted as the headmaster, because some equally situated persons they were given the pay scale.
Were they entitled? Were they entitled?
Yes. No, they were not entitled.
If they are not entitled, it's a it's your negative equality. You are
Negative
claiming
equality, my lord.
They are trying to make a distinction between the in charge and the officiating.
Officiating.
My responsibility.
According to whether they were entitled under the law as a officiating.
That is, as I've submitted, they
Were also
was
not
given
entitled.
out of turn.
So they were also not entitled.
No.
So you cannot claim parity on them. If they were not entitled under
We
the law.
cannot claim a positive thing from a negative.
No, this is that would be clearly amount to negative, claiming negative equality.
Yes.
Which is not permissible.
But only another that principle is applicable. On the other hand, the respondent authorities could not have met that discrimination. In fact, my lord, in paragraph 9, they have categorically stated that and it clearly shows how discriminatory they were. I have been a victim of discrimination. When a benefit is given to somebody, whether rightly or wrongly, attached to that post, I should have also be given that.
This is what I'm saying. It's not permissible. There's no concept of negative equality. It's always positive. For claiming parity or discrimination under Article 14, it's only positive concept. Sir, I've gone through.
That is some substance. That's
No,
why I didn't open my file also.
I've gone through your file.
And that is why I made my submissions. The fact are this.
So dismiss.
Yes.
I'll dismiss.
Yes,
Yes.
but only one principle as I have submitted. That aspect is the one thing. Another is whether they could have discriminated. Because
there's
it's
no
just
question.
in the name of officiating and in charge.
We'll not take into that. It's not. It's a bygone now. They were treated to be not properly appointed also, out of turn. So by virtue of operation of some office memorandum, they have been reverted back. They might have illegally appointed. If they have been, appointed, depriving you, then matter could have been different and allowed them to continue. Draw their salary. Because you have accepted your terms of appointment as in charge.
In 2009, they're supposed to have been reverted, but again, they have been given promotion. regularized.
Will dispose of. Heard, Mister. Dismissing it, or would you like to try somewhere else?
Otherwise, since these persons, though I have not made them the party respondent, but there is an order whereby they have been regularized in the post of headmaster.
No, that is a press cause of action. You do it. Heard, Mr. T. Patil, learned counsel for the petitioner. And also heard Mr. T. Tabu, learned counsel for the state respondents.
Yes, my lord. Respond number 2 and 3, madam. Standing Council Education.
By next paragraph, by filing this application, by filing this writ petition, the petitioner has assailed order dated 22/02/2017. Whereby the claim of the petitioner for scale of pay of headmaster of the vice principal has been rejected. Where is that impugned order?
But impugned order is page 18 of writ petition, madam.
18, huh?
That is the
Then the
engagement.
order
of-
says passed by so and so, huh?
Page 18.
Issued by the Secretary Education, Government of Arunachal Pradesh. No, to the extent of denying him the pay scale of headmaster in charge. Pay scale of headmaster oblique vice
Public
principal.
vice principal.
Next paragraph. The petitioner was appointed as what? TGT.
TGT, madam. Trained graduate teacher, madam. Junior teacher.
In the year 2004. Page 15.
15. Was appointed as trained graduate teacher
By order number ET 30.
by the order dated 26/05/2004. No, junior teacher, not TGT. Is it TGT?
Well,
It's
this
a
was
junior
known as
teacher, man.
junior teacher, but this has been
Now, it
Redesignated.
is yes,
redesignated
as
as,
TGT, trained graduate.
No, the petitioner was appointed on regulation as junior teacher within bracket Hindi. Now, now redesignated TGT, by the order that, 26/6/2000,
graduate.
26/05/2024. While serving in the said post, the petitioner along with along with one more TGT were appointed as in charge headmaster list of what is government secondary school police? What
Yes.
is this?
Government Secondary School, Police Colony,
Police-
Itanagar, madam.
Police
Okay.
colony.
It says GSS
Government Secondary School.
and posted, and then headmaster, in charge headmaster at government secondary school, police colony, Itanagar. without any extra remuneration until the posting of regular headmaster. Mr. Mr. It is contended that the petitioner on being appointed as in charge headmaster at the said school has served from
Almost 2 years.
from which date to which date?
From my date of joining is 4/9/2017
4/9
and till 17/9/2019.
4/9/2017
17 till 17/9/2019.
17/9/2019.
19, slightly more than 2 years.
The petitioner is aggrieved by the non-payment of scale of pay of the regular headmaster, public vice principal, on the ground that the juniors who were allowed to officiate as headmaster public BP have been allowed to draw the scale of pay of headmaster oblique vice principal. Next, Mr. T. Patil, learned counsel for the petitioner, submits that the action of depriving the pay, scale pay of the headmaster public BP to the petitioner, though allowed to serve as in charge headmaster, while the benefit of scale of pay to the scale of headmaster were provided to some of the juniors who were also allowed to officiate as headmaster. Is totally arbitrary and discriminatory. Mr. Then what else? That's all.
There were some decision by this same court pertaining to the same, almost same nature, but then this can be relied upon
I'm not
page 26 onwards.
20.
Otherwise, in my representation, I have explained my grievances. (435) WPC 435 of 2013 and also 222 of 2018.
Which violates Article 14, 16, and 20 of the Constitution of India. Next period. Mr. T. Patil Learned Counsel, while referring to the representation filed by the petitioner, submits that since the petitioner was discharging the same duties, discharging the duties of headmaster with utmost diligence, and I have carried out all the assigned responsibilities. There is no reason as to why the principle of equal pay for equal work should not be invoked. Mr. He submits that the persons who are equally situated are being granted the pay scale of headmaster public BP, having the same nature of duty and responsibilities. Mr. The form of the appointment of the petitioner by as in charge headmaster cannot be distinguished as the substance of duties, particularly the nature of duties, responsibilities has to be considered. Just while not doing that, well not. Mr. The
My lord,
respondent authorities had
the justifications they have assigned. May I take your lordship to page 9, which might be of some.
Which one?
consideration Of the affidavit in position filed by respondent 2 and 3.
that they have not been arraigned as a party.
No, not only that. No, that is because we were not agreed by their appointment. So nothing. Paragraph 9 at page 8. Down below. 4th line from the bottom. Page 8.
Page 8.
Page 8, paragraph 9.
Hmm.
4th line from the down below.
Yes.
If the principle of equal pay for equal work is applied in such case of temporary arrangement, the government would be left with no option but to close down the offices and institute at the cost of the general public when the regular incumbent proceeds on to leave. Applying the principle of equal pay for equal work in the incident case would be amount to non-application of judicial mind and it shall create a very bad precedent in the service jurisprudence. Hence, this repression is fit to be dismissed. But, this is totally discriminatory. In one hand, they are providing all these benefits, and they are trying to be very, very honest. And for me, they are taking this stand, but for others, they are not taking this stand. They have been provided. It is highly discriminatory. If they were conscious and concerned for the state exchequer, they would not have. Only this much.
That concern. Next, Mr. T. Patil, then council. Permanently urge that since the person similar situated had been provided with a similar the skill pay of administrators. Vice principal, the petitioner ought to be granted the same benefit as else it would be contrary to the principle of equal pay for equal work. Therefore, a direction may be issued to the respondent authorities to pay the scale of headmaster or vice principal for the period which is a period from 4/9/2017 to
04/2019.
yes 04
2019. 01/04/2019.
01/04/2019. Next period, Mr. T. Tagub, Learned Council, Standing Council, Education Department. On the contrary, submits that the petitioner was
Lord,
appointed.
it is not 040, 01/04,
No, no,
it is
that-
17/9.
Your duty was the vested on 1st April 2019.
Yes. 01/04/2019, huh? Submits that the appointment of the petitioner was purely on temporary as in charge headmaster of the school. The appointment order clearly stipulates that there would not be any extra remuneration. And it was only till the posting of regular headmaster. Therefore, the petitioner has no right to claim for pay scale of the headmaster of the vice principal. Next. He submits that though the petitioner has claimed for similar benefits granted to some officiating headmaster. By now, since the appointment of those persons, they have been the appointment, no. The persons similarly situated are not implicated party respondent. The persons claimed to be junior and similarly situated who alleged to have been paid the scale pay of the headmaster and vice principal have been reverted back now as their promotion on officiating were found to be out of turn, contrary to the office memorandum of the state government. Therefore, he submits that the petitioner is not entitled for grant of any pay scale of the headmaster, as he was given as in charge headmaster only till the posting of regular headmaster. I've considered the submissions of the council. The issue raised by the petitioner is basically a fundamentally claiming equal pay for equal work, claiming for payment of pay scale of headmaster of a vice principal on the principle of equal pay for equal work. Mr. It is seen that the petitioner has petitioner was appointed on in charge, appointed as in charge headmaster of government police called Itanagar with a certain conditions. Mr. The appointment as in charge headmaster was without any extra remuneration until the posting of regular headmaster. Mr. The petitioner has accepted such appointment with certain with the accepted the appointment and served the school as in charge headmaster for 2 years. Mr. You have filed this writ petition on when? 2018, before completion.
Yes.
After the acceptance, having been accepted, after accepted the appointment as in charge headmaster with the conditions stipulated there, the petitioner is filed this writ petition claiming the pay scale of claiming for grant of pay scale of headmaster public vice principal on the ground that similarly situated teachers who have been appointed on officiating basis illegally have been granted the same pay scale, granted the scale pay of the headmaster, public vice principal. The grievance is basically the grievance raised by the petitioner is fundamentally for invoking the principle of equal pay for equal work. Next paragraph. On consideration of the matters in its entirety, this court and the facts and circumstances attending in the present matter. This court is of the view that such contention cannot be accepted as it is as there is no concept of negative equality under the law system. The law only always provides for a positive, and it is only concept of positive equality. As the claim of equality to those persons appears to have been granted not in accordance with the law, either to their promotion as well as the benefit of skill pay system. If such an claim is allowed, it would amount to perpetuate, allowing the perpetuation of illegality. In any case, by now, the persons whose list to have been granted promotion on officiating basis and granted the scale pay of headmaster, public vice principal have been reverted back as it was found to be not in accordance with the law. Thus, the claim of parity of the petitioner to those illegally appointed and granted pay scale cannot be accepted. In the case of, I'll just give one case, in the case of so-and-so, the Honorable Supreme Court has said, has held that there is no concept of equality under Article 14. It only envisages the positive concept, positive equality. Having considered in view of the above discussions, in view of the discussion made herein, I find no merit in this petition. Accordingly, this petition stands disposed of. This stands dismissed. No order is to pass.
Deeply apply. Right, sir.
Yes,
Matter may be adjourned for today.
yes. What is this?
Criminal petition, Lordship.
Criminal petition of what?
For quashing the FIR, Your Lordship,
Hmm.
on merit, Your Lordship, according to them, the 2 FIR has been filed.
Hmm.
The subsequent was registered on, Your Lordship, initially, the first FIR was filed on, it was actually not an FIR, but the first complaint was filed on 18/8/2021, which was not registered. And subsequent to that, on 29/10/2021, the second FIR was,
Dispute is of purely civil in nature. Is not it? They may have taken the different ground,
yes, Your
but
Lordship.
it appears dispute is civil in nature. Purely. There's a transaction between them. Is not
That is,
it?
yes, that is there, Your Lordship.
They have
that-
invested some money,
Yes,
invested some money,
Yes, that
and it
is,
was not paid back.
that is,
Is not it?
yes, Your Lordship.
You are for respondent,
Yes. Lordship, complainant.
complainant.
Kindly see
Complainant respondent.
complainant respondent. So, the issue is not, that is not the issue. The issue is that by using tax certificates, he has obtained the trading license and get registered himself as a contractor. That is the issue.
It's a case of forgery.
Forgery. 468.
Later on, when complaint was lodged, he cancelled got cancelled on request to the competent organ. And in those period, he was using that
Force document.
for document for personal benefit. That is the issue. That
On
is
the
why
prayer of
case is
Mr.
registered. Yeah, that is why case has been registered.
He is seeking time. What to do?
Yes, yes. Matter required to be heard.
Heard Mr. So-and-so. Learned counsel appearing for Mr.
Then,
L. Permit, learned counsel for the petitioner.
Your Lordship, my only prayer would be, Your Lordship, we have the CD original, so it may be returned back, Your Lordship.
Which one? CD?
Yes, Your Lordship, original
Okay.
one.
In that case, you Prayer has been made on behalf of Mr. El Perme, Learned Counsel for petitioner by Mr. So and so, Learned
Yes.
Counsel. That the matter may be listed after
Vacation, lordship.
4 weeks. Mr. T. at the Learned Additional PP. And Mr. T. Tapak, Learned Counsel for response. Are present, Mr. Come on. Since the Learned Additional PP has received the case diary,
Yes, your lordship.
come on. And the matter is adjourned, come on. The case diary be returned back.
Deeply obliged.
And the same be produced on the next date.
Yes,
List after 4 weeks.
deeply obliged.
Your lordship, may I please? This is joint petition also in connection with Ruxin PS. In connection under section 279, 338 and 427, 304A.
Hmm.
Here the case regarding 341, which is non-compoundable in nature also. May I take you to the FIR also?
Where is FIR?
FIR is in page number 18, which is a type copy. May I
Yes.
read? Also. To the officer in charge, Ruxin PS is young. I am to inform you that Sri Tayam Payang, so and so, village so and so, were coming from Pasigat to Ruxin on so and so, on a bike register number so and so, was hit by an Alto car, register number so at Leku at around 8:30 p.m. Driven by Inayam Fukan, an employee of Vinaya Tea Company. In the process of Sri so and so sustained serious injury and was referred to evacuated to AMC Dibrugarh in the serious condition, and the another one Sri so and so sustained serious and got admitted in private clinic. Lordship, in this case, one person sustained injury and one person had been died, Lordship. This
Died?
case. Yes, Lordship.
Yes.
Regarding 304A, Lordship. Now this petition has been filed by all the petitioner, Lordship.
Yes.
Here the petition number 2, who is the legal representative, Lordship? Victim's father, Lordship. Now the case is, they have settled among themselves, Lordship. And I have bear the medical expenses. Also, I have paid the funeral service of the petition number 2, Lordship. In the page number 34, Lordship, this is the settlement deed agreement, Lordship, between the petitioner and the accused person.
Yes.
Page number 34, Lordship.
Yes.
Now my prayers at this stage, this matter may be set aside and paused. Earlier I was given interim. The matter is pending before the Ruxin PS, Lordship, in the CGM ASEAN. The matter is pending before the CGM Ruxin, Lordship, or Pasigat. And if you go the further trial, so there is hardly any chance of get conviction in this case also.
Your lordship may kindly come to page 34, your lordship. The only issue here is which has been raised in the many occasions before this honorable court. The date of the settlement, your lordship, there is discrepancy, your lordship, discrepancy on the date, your lordship. This is continuation with the settlement agreement made on 30th day of January 2013 at Ruxin as per Medium Kaba given on 22nd December 2012. This present settlement this is executed on this 14th June 2022 at Pasigat. So now, your lordship, they are referring to a Kaba decision, your lordship. So what exactly has happened in the Kaba decision, and the date, here it says is continue of the Kaba decision of 30th of January 2013. And it says the Kaba decision was given on 22nd December 2012. So how many Kaba was, in how many occasions Kaba was held? And what was the decision of the Kaba, we, your lordship, don't know here. Which date has to be taken into consideration, your lordship?
We have seen the agreement, settlement is for the purpose of 482.
Yes,
Page
sir.
37.
The 14th June 2020.
It is not the page 37. In every settlement, authorize so and so to quash petition, quashing petition under so and so.
Yes. So now what?
This is not what Supreme Court intended.
Yes, your lordship.
The settlement has to be I mean, it should be done on volition. It
Yes.
should be voluntary.
Yes.
Then only we'll look into the settlement.
Yes.
But we have seen maximum 99% cases of 482
Yes,
when
yes.
there is a settlement. They said
In a
we
mechanical,
authorize.
yes, in a
and we
mechanical
will
manner they approach,
the
your lordship.
court for quashing.
And it should be a reasonable one, your lordship. The consideration must be the
It's
reasonable
basically
consideration.
for quashing. You
Yeah.
don't want to press the trial. That's all.
Yes, your lordship.
We'll have to take a different step.
Otherwise, also in many occasions, your lordship will raise the issue that certain consideration has to be taken to what, under what circumstances they have settled the
Yes.
matter, your lordship.
We'll have to, it has to be, what has to be convinced.
Yes, your
We'll
lordship.
have to convince that really it is a settlement.
Yes, your lordship.
But maximum cases,
Only for avoid the trial, your
what
lordship.
this court is taking little lenient view, considering leniently considering the matter only, we're allowing the petition. When things we cannot allow to go on like this. You
Yes, sir.
file those KEBA decisions. This settlement is only for filing this petition only.
Yes.
Yes,
Which is not it cannot be intent of the law or the laid down by Supreme Court.
Your lordship, if I'm fairly, I submit.
It has to stand in a different on its own. The agreement has to be, a settlement has to be different on its own. It's not, should not be a letter to file a petition or a stepping stone.
In fact, your lordship, the KEBA decision was not made, it was made only orally. In fact, on the letter it said through this deed agreement.
Then all will not allow this. This is only for filing the petition, you have made the agreement.
If you see also 304A, it is for two, maximum
See,
punishment.
court has to look at this agreement separately. It has to stand its own, not a stepping stone for filing the petition. And hopefully these are not drafted by the lawyers. In criminal petition nowadays, for quashing,
I have understood, but
I've realized lately, this court has realized lately, because normally we believe on the settlement. But maximum 99 cases, at the last there will be a paragraph, yes.
But it may also be so, maybe they have already settled, and when this trial comes up, then they draft this thing, that may also be the reason.
It's basically, maximum are basically to avoid the trial.
Ultimately, when trial starts and someone comes.
Of course, nobody would like to face the trial. Shortcut. You find out that agreement,
Yes, Your Lordship.
the Keba decision, we'll produce, file that, we'll see. All right. And Mr.
Vitaba.
Beta, London Council, and also had Mr. Theatre London Additional PP. Do you have the records? We'll keep it for some time.
Yes, sir.
It is
It's, I think, scan copy, Your Lordship.
Okay. On the perusal of the settlement by the parties, settlement, copy of the settlement deed annexed in the written petition by the parties, by the petitioners. It is seen that the settlement has been made in continuation with the Keba decision. In continuation with the settlement agreement made on 30/01/2013 and the medium Kebang decision dated 22/12/2012. Considering the petitioner is granted 2 weeks time to file the copy of the settlement agreement and the Keba decision as referred to above. This better after 2 weeks.
In fact, Your Lordship, this method has been met, only orally it was met. Later on, I only made this execute.
Then in that case, if any, if you don't have, you file an affidavit. You file an affidavit to that effect. But you have said a settlement agreement made on so and so.
Yes. In fact, they had a proper
It
meeting.
doesn't say the oral or something like that.
It ought to have reflected in the agreement, then everything would be clear. Anyways. Obliged, Your Lordship.
Much obliged.
Yes.
This should have mattered in fact come up for motion. Delay was gone on the last occasion and my learned friend was not present on the next date.
Hmm.
This is a case, my lord, wherein the learned district judge has conferred jurisdiction upon himself. Your lordship may kindly have page 24. My lord knows, but I am just refreshing your lordship.
Page 24.
24, the Arunachal Pradesh Civil Courts Act.
Hmm.
Yeah, list of dates कहाँ है? ये ना? अरे ये बाहर रख देना. My lord knows after the coming into force of this act, the
Yes.
village authorities have been conferred the status of customary courts.
Yes.
And my lord may kindly have section 15(2) for a moment. At page 26.
26.
15(2).
15.
Appeals to the decrees and orders passed by a court of civil justice senior division in original suits, my lord. In original suits and proceedings of civil nature, shall which appeals are allowed by shall lie to the district judge. Original suit, my lord. Now, what has happened? I have just prepared a list of dates. The unnecessary, my lord, I will not bother Roshi with the documents. Just point out what has happened.
Yes.
Now, my lord, may kindly have a list. I will just, I will not bother. 3/1/2016, a complaint was lodged by the respondent, my lord, regarding a land dispute. 24/5/2006, a kabang was held, dividing the disputed land into two equal halves. Against that, my lord, the respondent filed an objection, my lord. The objection was for holding a re-kabang. That is at page 40. If your lordship like to peruse, that is there. Page 40. That was on 2006, my lord. Then, my lord, ultimately there have been misconceived petitions by both the parties and rightly dismissed by the London Civil Court, by both the parties. Ultimately, this objection, my lord, 26/5/2006, it appears that was transferred before the district judge,
Yes.
London district judge. If your lordship may kindly have page 58. By this
Yes.
order, by this order, this representation was treated as an appeal. And my lord, the parties were provided opportunity to file reply. Ultimately, my lord, consequent to the amendment, my lord, Civil Court Act amendment, the matter was transferred before the Civil Judge Senior Division. My lord will note that it was treated as an appeal, that objection.
Okay.
Then my lord will have kindly have page 86. The Kaba decision was upheld by the learned Civil Judge Senior Division while exercising jurisdiction as an appellate court. Page 100, your lordship will find. The appeal stands dismissed.
Appeal by
Appeal by the, in fact, it was not an appeal. It was an
representative.
representation that was ultimately treated as an appeal by the learned district judge by order dated
And it was
20
transferred to civil
Yes,
judge.
civil judge.
Senior division.
Senior division.
Appeal by whom?
Appeal
Appeal
by
by representation.
Hmm.
Okay. That has been dismissed.
dismissed.
Okay.
Yes, page 100.
Yes.
So, my lord, the learned civil judge senior division was exercising appellate jurisdiction, my lord.
Yes.
Dismissed. Then, my lord will kindly have page 104. Against that order, 5/6/2023, by the Civil Judge Senior Division. Page 104 is the copy of the memorandum of appeal. This is the synopsis part. Your lordship will kindly have page 107.
Yes.
This is an appeal under section 15(2) of the Arunachal Pradesh Civil Court Act 2021. Though it was an order passed in appellate jurisdiction. Now, we objected to this, and my lord, by this order at page 119, the learned district judge confers jurisdiction upon himself. Not only does he say that the village authority cannot be treated as a court, he goes on to say lots of things. Page 119. Relevant would be, my lord, page 122 onwards.
Hundred and
22. Second paragraph onwards. Now,
yes.
second paragraph. Now, if we count the appeal from village authority to inter-village territorial court, it must be treated as first appeal as per the act. If the parties preferred appeal against apex customary court, then it shall again be treated as second appeal. Hence, the appeal before the civil judge addition, as the case may be, shall have to be treated as third appeal. With
There will
great-
be fourth appeal and fifth
with
appeal.
great respect, those appeals will
So
go
and so forth.
only lie if the parties agree, my lord. However, as per the CPC, there is no provision beyond second appeal. After reading together the entire provision of the Act, it is noted that the APCC is silent on second appeal, but when we read together the amendment of the Act in 2022, inserting the provision of subclause 4 of such and such, it can be concluded that the appeal from village authority or from inter-village customary court or apex customary court or civil court is the case maybe cannot be treated as an FO jurisdiction, first appeal jurisdiction, but it must be treated as an appeal from quasi-judicial authority manner. Despite the act saying that providing the status of a customary court. The village authority, although having original jurisdiction of the respective area, but they do not decide the case in terms of the Code of Civil Procedure, taking evidence on oath, but they summarily try the case without examining the witness and parties on oath. Whatever it may be, my lord, the act provides a thing to be done in a particular manner, they do it, my lord. Reading together all these related provisions, the judgment or order from the Court of Civil Justice shall lie to the Court of Civil Justice Senior Division in case of appeal from the village authority or from inter-village territorial court or apex customary court, like original jurisdiction is the case in the civil judge senior division to the additional district judge or district judge, as if it is decided in original jurisdiction, as the court has already have the original jurisdiction over the suit matter, but only due to the existence of village authority, the matter was bypassed to them to reach before the original court. Moreover, the appeal from village authority cannot be exactly termed as an appeal like original jurisdiction, where all the evidences are collected and on appeal, the matter is decided evaluation of evidence or appreciation of evidence or discussion on law points, but the appeal from village authority are missing of all these ingredients of character of appeal. Hence, every decision of civil judge and civil judge junior division has to be treated as exercise of original jurisdiction on appeal from village authority. The APCC Act does not use any term of first appeal and second appeal like CPC. Under CPC, the second appeal shall lie to the such and such, such and such. In view of the above, I am the opinion that every order or judgment of civil judge exercising original jurisdiction or deciding an appeal from village authority shall lie to the additional district judge or district judge, as the case may be. My lord, I am assailing this, my lord. How can he confer jurisdiction upon himself, my lord? Confirmation of jurisdiction, my lord, is a legislative function, my lord, is a settled position of law. By this, my lord, he conferred jurisdiction upon himself. My lord has seen 15(2), an original order will lie and appeal. So how can my lord the learned civil with due respect, my lord, come to a finding like this?
According to appeal lies where?
Now, my lord, if it is a second appeal, it will lie to the district judge. This will go for second appeal. CPC is only high court, but I'm just a moment. Whatever it is, maybe CRP, if no appeal lies, CPC not.
CPC, Civil Procedure Code.
वो हमें बैग में. In any case, my lord, how can the learned district judge, my lord, confer jurisdiction upon himself? Consequently, my lord, the appeal was decided and remanded back to the learned civil judge senior division. When the first order itself is bad, my lord, the second order would be a nullity.
Any court, subordinate to the High Court. Second appeal will not lie to the district court. It will lie to the High Court.
High Court will lie to the High Court. Or if your
What do you
lordship,
say?
if I may place one judgment, my lord, your lordship knows but one paragraph. 2013, 10 SCC, page 136.
SCC
Yes,
What?
136.
136.
136, paragraph 9, my lord.
Yes.
Indisputably, it is a settled legal proposition that conferment of jurisdiction is a legislative function. It can neither be conferred with the consent of the parties nor by a superior court. And if the court passes a decree having no jurisdiction over the matter, it would amount to nullity as the matter goes to the root of the cause. Such an issue can be raised at any stage of the proceedings. The finding of a court or tribunal becomes irrelevant and unenforceable, inexecutable while the forum is found to have no jurisdiction. Similarly, if a court tribunal inherently lacks jurisdiction, the acquiescence of the party equally should not be permitted to perpetrate and perpetuate defeating of the legislative animation. The court cannot derive jurisdiction apart from the statute. Apparently, my lord, it was totally without jurisdiction. Just my humble.
Yes.
Yes.
Okay, I'm submitting to my understanding of law. This, as per the submission of my, this section 15, the issue is over the jurisdiction. Jurisdiction issue to file appeal against the decision of the civil judge senior division. In this case, on reading, plain reading of the language of the section 15, this case is connected with the special law. Because land in issue has been already settled under the Regulation Act 1945. First of all. And what is the remedy before the remedy against the decision of the village authority? In that case, earlier it was Deputy Commissioner. Now, after this amendment of that AFR 1945, it is also for the Civil Code Act 2021. Under the section 15, kindly see, all the this section has been given. This ordinance.
No, we'll not go into all those details
Yes,
now.
I'm coming to the point. This point is kindly read the section 15. Section 15 says.
Yes, I have read it. You tell us.
Yeah. My interpretation, my part of interpretation is because as per the latest amended provision of this Regulation Act, this village authority appellate jurisdiction is, first jurisdiction is the inter-village council or village authority, inter-village, and all the affects customary code. And then as per, and whoever agreed with the decision of the customary code comes before the before the court, regulars under Civil Code Act of section 15. The section 15 says, under the clause 1, appeals from the decree or order passed by the Court of District Judge and the Court of Additional District Judge in original suit and proceeding of civil nature. My case is the proceeding of civil nature. This is not a case of original jurisdiction because case was not filed before at the first instance, not filed.
Huh?
This is a case of proceeding of civil nature. Here is a.
It's not the original,
This is not the original jurisdiction.
therefore,
Yes, original jurisdiction. Appeal from the village. The root of.
That's what he's
source of-
saying.
Source of law is lordship, this AFR 1945. That is why.
exactly what he's saying. It's
Wait.
not the original, original suit.
Yes.
It was an appeal.
Whoever, that is why I am to say, whoever agreed with the decision of that
Civil
judge
judge,
senior
senior
division
divisional.
has to file under the proviso 1 before the High Court. This jurisdiction is before the High Court in the form of appeal, not in the form of revision. Because no provision has been defined under the Special Act for filing revision.
No,
This is
first,
one of-
first we'll come back.
This
to-
is, this
First,
is,
we'll come later to that. First, you tell us whether the appeal lies
yes,
against the order of the civil judge,
yes, civil judge,
senior division,
Yes.
on an appeal to the district judge.
yes, district.
First, we'll decide that.
That is the part 2. I'm saying, in case the person.
That is part one.
Yes,
We'll
part-
go to
and
the part two.
Part 2 says, proviso 2 says, appeal from the decree or order passed by the Court of Civil Nature. Order passed by the Court of Civil Nature, senior division, civil judge This is Court of Civil Judge Senior Division.
Which you are reading,
Kindly see,
which one you are reading?
yes, I'm reading the book, Lordship, reading the book. I'm reading the book.
Which
of
provision?
This appeal provision under
15,
section,
15(2),
section
subsection
15,
2.
Subsection 2.
Yes, you
That
read
is
it.
why I am stressing over that provision provided to appeal from the degree and order passed by the degree. What is degree and orders passed by the Court of Civil Justice, Court of Civil Nature, Senior Division, in original suit and proceeding of civil nature. There are two kinds of proceeding. One is original suit of the Civil Justice Senior Division, and another is proceeding of civil nature. That is with relating to Keba nature. Shall, when such appeal are allowed by law, lie to the Court of District Judge of that district or in the Court of Additional District Judge where such court exists, or the High Court as the case may be. To my understanding of this legislative intent of this proviso says
It's not proviso,
this is
subsection,
subsection 2.
or we call it clause 2.
Yes, clause 2 of 15.
What is this? Clause 2 or subsection?
Clause 2. I'm pressing on clause 2.
Subsection or
Subsection
clause 2?
clause 2. Yes.
No, either it's subsection 2 or
Subsection-
clause 2.
Subsection.
Okay.
It is clause 2. Section 15 of clause 2. Clause 2 say,
We'll read it either
there
way,
is a clear cut language,
either of the.
has been used. Whoever is agreed with the decision of the Civil Justice Senior Division, the jurisdiction is before the appellate jurisdiction is before this district judge. Accordingly, rightfully, this order has been passed, degree has been passed by the civil judge. And whoever agreed with the decision of Civil Justice Senior Division, that the district judge is having jurisdiction to appeal before the High Court under the 15 clause 1 again. And before that also, as per the Civil Court Act, in the village authority also, there is a 2 stages of appeal. In the Civil Court Act also, there is a provision has been made for 2 stages of appeal. To my understanding, this is the language used by this legislator. And third one, may come to third one, 15, clause 2. Appeal from the degree order passed by the Court of Civil Justice Junior Division in original suit or civil nature. When such appeal are allowed by law, shall lie to the Court of Civil Justice, again, Senior Division. This says, language of this legislature says, when order of the Civil Justice Senior Division, Junior Division pass an order, decree, the appellate court is before the Civil Justice Senior Division. When, under the clause 2 again, I'm reiterating, when the decree or order is passed, if the parties agree, the competent court to deal with that case is before the district judge. That cannot be said. There is anything that confirmed by himself to decide the matter. But the court has rightfully applied the mind by reading that this provision incorporated in the particular provision of law. And again, kindly in conjunction with this appeal provision, kindly read the AFR section 24 of the AFR 1945, section 24. Section 24 says, and you see, this with regard to the law, apart from them, Civil Justice Senior Division or Civil Senior Division, Junior Division or District Judge. What is the sources of law? That is as an appellate court. Because section 24 of the AFR 1945 has conferred right of appeal before the civil court. The language of the section 24 of FR says, kindly read, may I read again about the provision of law? How this particular section 15 has to be interpreted to understand the law. There is a conflict in the jurisdiction. There is nothing, any error in the past order passed by the district judge, because law is clear. Law has conferred, because when the AFR law is clear, when this FBCC ordinance for the civil court act is clear, that CPC cannot apply. When there is a conflict of general law versus special law, the special law has to be applied. But CPC comes later. First, this law has to be interpreted and applied upon. We cannot. I'm reading the section 24 law.
So according to CPC doesn't apply.
CPC applied in spirit.
What is Civil Courts Act?
Lordship. That is
Is
why
it a special law?
this is a special law.
I'm sorry.
Because AFR 1945 is not the CPC. It is a special legislation to protect the tribal people. First, that has to be understood. Then, AFR 1945.
Do you
has to be
read the first
I'm
page,
reading the
page
section
23,
24.
page 20, that Civil Court Act, you read it first.
Page 20.
No. You are reading that
Section.
Arunachal Pradesh Civil Courts Act.
Yes.
You read
Section
that, first page you read it. The preamble,
I have read the section 15.
not 16, 15 will come. You said it's a special law, you just read it. First page,
By this legislation law, it kindly.
No.
First page.
First page.
Page 9.
page,
Page 9 say, page 9 says,
yes,
this act, to consolidate that.
yes, read it loudly.
Yeah.
Let us understand.
To consolidate
law
the
is this?
relating to civil court. And for establishment of various civil courts, for speedy disposal of civil cases in the state of Arunachal Pradesh and matter conducted therein and incidental thereto, be elected by the legislative assembly of the state of Arunachal Pradesh in the 7th. This act may be called as amended civil court. Civil courts. Act.
It's okay, more than enough. First 3 lines. What do you mean by this? To consolidate the law relating to civil courts and for establishment of various civil courts for speedy disposal of civil cases.
Yes. That is why, by this.
That is why this is not a special law,
That is why by.
as you have understood.
By this civil court act, this AFR 1945 has been, my submission is AFR 1945 has been modified. AFR 1945 has been modified. Kindly see page number, this section 24 of the AFR.
In view of the enactment of this act,
Yes.
the AFR has to be amended again. That's the
That amendment is a part of legislation that may be.
so we're concerned, let us confine to 15.
Section
Two.
15(2).
Yes,
I'm
and there's a difference of sentence in subsection 2, it said original suits and proceedings of civil nature.
proceeding.
In subsection 3, it says in original suits or proceedings of the civil nature.
Civil. There are,
What is the difference?
to my understanding, though I am reiterating what. The order passed by the civil judge senior division has an appellate jurisdiction before the civil judge senior division. And
We're
order
not
passed by the-
disputing. We're not disputing.
Yes.
If it is an original suit,
this is not the original suit law.
that's the
Not the case
reason.
of Original suit.
This is what he's saying. It's not an original suit.
This is of civil nature, but that is why I'm reading the section 24 of AFR 1945. Kindly see, 45 regulation. This. This says.
Is there any,
Mary, this.
I
law
just
is-
wanted to know,
This
is,
law is connected with the section 24 of AFR. Kindly read the section 24 of AFR 1945.
yes,
This says, any party aggrieved by the decision of the village authority may appeal within 30 days before inter-village territorial customary court or apex customary court by whatever may court, who on receipt of such appeal shall dispose of the case, provided that proceeding in the village authority, inter-village authority or customary court or the apex customary court as the case may be, shall be recorded in writing in a respective vernacular or English or as the case may be, and provided further that if agreed by the parties or if the agreed party desires to appeal, in this is the case, I am desiring to appeal, as the case may be, an appeal arising out of the decision of the village authorities, decision of the village authority, arising out of the decision of the village authority.
yes, thank you. We'll admit and list it for hearing. All right,
Lordship, this is already 2006 case, Lordship. 2006 case, land dispute case. Today it is 2020.
but before this is, it's CRP 09 of 2024. It was
Look,
first moved on,
This is
Proceedings before the civil
Lordship.
judge senior division has to be stopped.
yes,
Lordship, kindly see
Then not a question
already
of two thousand
the
six.
decision.
session judge,
Lordship.
He has remanded the matter back to the civil judge senior
already
division
trial
for
going
trial.
before the
Then will have to be stopped.
which one?
By the impugn order,
Yes,
by the 710 order, he confers jurisdiction upon himself.
yes,
Then thereafter 2212, he passes an order remanding the matter back to the learned civil judge,
two impugn orders are there,
two impugn orders.
okay.
This 22/6/12 order just cannot stand in light of the 710 order, which is totally the jurisdiction.
This is a revision matter, Lordship.
Yes.
This matter may be disposed of, Lordship.
No,
The
it cannot be
final
disturbed.
solution
The way you are arguing the matter, it will take time. It will,
Where is the solution, Lordship? Already matter.
we'll hear it, we'll admit it and we'll hear it, fix it for hearing. We'll hear you. All right,
Lordship, this matter says, Lordship, as per the rule 24 says, I am submitting of the AFR 1944 says, this application appeal filed by the aggrieved party should not be dismissed on technical ground, says, provider says.
yes,
It should be tried de novo. But likewise, the already district judge has
the district judge has remanded back the
Yes.
matter to the civil judge.
remanded.
Right,
the-
rightly or wrongly, the civil judge senior division has decided in appeal. The
ultimately-
next forum is clearly not the district judge. There must be a forum. They should approach that, not the district judge. It is clearly with the jurisdiction.
I'm not submitting that next forum with district judge. I am submitting that district judge already passed an order.
We'll
Try-
stay, we'll
try-
stay, we'll
try
stay,
the matter before the civil judge senior
They
division.
will stay
What
that.
is going on there?
we'll
There
stay
is
there.
no issue.
Till the disposal will stay there. All right. And Mr. Deepak, learned counsel for the petitioner. And also had Mr. T. Tapak, learned counsel for the respondent. How many? Only one?
Yes.
All responded.
By filing this revision petition, the petitioner had challenged the, what is that order?
Ordered at the 7/10/2023.
710, where it is?
That is 119, my lord.
7/10/2023. Passed in, what is PSG civil appeal? Is it
Yes, 06.
appeal within bracket Keba? C number 06 of 2023.
As well as the order dated, judgment and order
And-
dated 22/12/2023.
Where it is
125.
and order the 22/12/2023. Whereby the passed by the learned district judge East Siang Pasigat, whereby the appeal filed by the respondent against the order
Of the civil
the
justice.
civil judge senior division
Yes.
on an appeal has been allowed and remanded the matter to the learned civil judge senior division for what? Retrial,
Retrial.
for retrial. Admit the revision petition and list for hearing. After
So that will be fixed for disposal.
hearing, while fixing it for hearing,
For disposal.
after 2 weeks. 2 weeks or 3 weeks? 2 weeks, 2 weeks. That's correct. On consideration of the grounds of challenge to the impugn orders. I'm of the firm view that the learned district judge East Siang Pasigat has wrongly exercised the jurisdiction in the present matter. What was this first sentence? Accordingly, till the disposal of the revision petition, the impugn orders that is so and so above shall remain suspended.
Particular that.
You decide.
Minor
All of
records
you are
would also
there.
have to come, I believe.
Okay, call for the records before the,
Come for orders.
before the interim,
After 3 weeks, record my report.
After 2000, they say all of a sudden he's in a hurry. Unbelievable.
But it's interesting. But then you have to be very clear.
What I have
But don't make it a jalebi. Be clear and you assist the court. It's an interesting issue. Third, fourth appeal. Right?
That is the
It's a, we understand
provision itself is.
it's a,
When, we have to
the-
in that line.
the peculiarity in the state. This has to be, I mean, settled. I don't understand why this, it said original jurisdiction and the proceeding civil in
I have
nature.
understood what this my learned friend is trying to twist.
No, in that provision.
Yes, I have understood that.
Original,
That-
original suit
Only
and the proceedings in civil nature.
Civil.
And then in 3, it says or, not the and, it is or.
the only thing that it can mean is the proceedings has to be civil nature. It cannot be a criminal proceeding, madam, or any other proceeding. It has to be a civil proceeding.
No, that's
It may-
why this has been added.
I don't know, but
And what is the difference? What is in 2 subsections? One is and, other
in,
one is
in
or.
any case,
Hmm.
the issue here is original jurisdiction. Apparently, the civil justice senior division.
According to you,
accepted
what he is
jurisdiction.
trying to argue is, it's not only original
I
jurisdiction.
have understood that that cannot be in terms of what is provided in the act itself. For appeal
So
from
he
the
wants
judge
that-
where it lies.
He wants that in to suit his case, this original suit has to be read down or
Yes.
read
I have
out.
understood, I have understood, yes. The whole act, because today is the motion stage, my lord, I am not pressing everything, my lord. My lord, so this 7/12/7/10/2023 order and the 22/12/2023 order has to be stayed.
And that's why I missed
Yes.
it.
7/10/2023
Yes.
and 22/12.
Aforesaid order, impugn orders, I'll not, the orders, you just write there, the so and so shall remain stay, the impugn order so and so shall remain stay.
Obliged.
You mentioned that there. impugn order.
Yes, Tom.
Please, Your Lordship.
Yes,
Though the brief looks voluminous, the issue is only one, Lordship.
yes,
The issue is in PMJSY road constructions, before issuing the NIT, they prepared the DPRs. The DPRs are approved, then NIT is issued. For the preparation of the DPRs, they need to furnish a land availability certificate. For that, since there is no proper land acquisition process for acquisition of land, they make some mechanism, by taking the consent of the villagers, by involving the panchayat leaders, this sort of thing. For that, they have to make some affidavits, by which the villagers who are willing to donate may donate. They try and persuade that. In this case, what happened is, before the issuance of the NIT, no such thing was done for us. We are the landowners. We had met representations to the Deputy Commissioner also. Deputy Commissioner has also wrote that things should be done in a proper manner, that I will show later on. Then they have simply issued the NIT. Now I have annexed the DPRs also. It is very clear that the land availability certificate obviously was not annexed in the DPRs. Now, my lord may see, first of all, the issuance of the NIT is not in dispute. Of course, once they've issued the NIT, then it was cancelled. Then again, they've issued the NIT, and again it was cancelled. But it was found that the NIT was not actually cancelled. That is what they have brought in by way of affidavit, saying that we have not cancelled the NIT. But since we are villagers, we do not know what happens in the office. We only rely on what is published in the newspapers. We have brought the copy of the newspaper also. In that, the NIT was cancelled, but in practicality, it was not. Actually, that is our stand also. Now, Lordship may see page 61.
61.
Yes. This is the letter written by the Secretary RWD to the Deputy Commissioners of Tawang, East Kameng, Kradadi, Kurungkume, Upper Subansiri, Upper Siang, Siyomi, Lower Dibang Valley, and Anjao. Now we are concerned with Kurungkume district. Lordship may see, this is regarding acquisition of road length with ROW for the road projects proposed under Vibrant Villages program. Lordship may see para 2. It says that the land being a state matter, it is the responsibility of the state government to oversee that the lands are available for taking up the proposed road works. The process of making land available for the road works should be just, equitable, and serve the common good. The details of the land available, the details of the land made available should be reflected in the local land records to prevent dispute. It must be noted that the central government does not provide funds for land acquisition under PMJSY. On the other hand, due to resource constraints, the state government may also be unable to cover this cost To address the issue of land acquisition, it has been suggested to explore the mechanism for voluntary land donation, signing of MOU. Such voluntary donations should be documented through affidavit, copy of which shall be forwarded to the local revenue officials for making necessary changes in the ownership/possession record of the land. The use of voluntary donations and proper documentation is intended to streamline the process and avoid disputes involving the local community in decision-making processes, fosters a sense of ownership and ensures that the road project aligns with the community's needs and priorities. It also helps in identifying the potential challenges and solutions. A specimen of such an affidavit is enclosed for use in documenting voluntary land donations. The process for land donation drive requires organizing a transit walk by the administration, associating departmental engineers together with the Panchayat Pradhan, local revenue, /land record officers, /staff and forest officials. On completion of the event, a proceeding of the meeting shall be drawn and duly signed by all the stakeholders. Upon open and transparent communication between the community and the local authorities builds trust. Therefore, in ensuring successful drive, it is essential that all stakeholders are well informed about the project objectives, benefits, and potential impact on livelihoods. So basically, while this donation drive is done, then they have to organize a transit walk. This is also as per the PMGSY guidelines.
Yes.
So Lordship may see the PMGSY guidelines, the relevant portion.
Transact what?
Yes, transit walk.
Page,
Lordship, Lordship, before that, page 155, this is part of the PMGSY guidelines. Actually, it starts at 148, but I would like to point out 16.2 of page 155, part of the PMGSY guidelines.
page,
155, 155.
yes,
6.12
yes.
in that page, 6.12. It will be the responsibility of the state government /district panchayat to ensure that the lands are available for taking up the project roadworks. A certificate that the land is available must accompany the proposal for each roadwork. That is, in the DPRs, they have to have the land availability certificate. It must be noted that the PMGSY does not provide funds for land acquisition. This does not, however, mean that land acquisition cannot be done, by the state government at its own cost. The state government may also lay down guidelines for voluntary donations, exchange, or other mechanisms to ensure availability of land. The process for making land available for the local roads should serve the common good and should be just and equitable. The details of land made available should be reflected in the local land records to avoid dispute. Then, Lordship, the transit work, that is at page 157, part of the same guidelines. Lordship may see the second para, 8.4, just on the top. While commencing with the mechanism of the DPR, the PIU will hold a consultation with the local community through the mechanism of Gram Panchayat in order to determine the most suitable alignment sort of issues of land availability, including forest, moderate any adverse social and environmental impact, and elicit necessary community participation in the program. For this purpose, the PIU will organize an informal transit walk as follows. The transit walk shall be undertaken by the AE/JE accompanied by the Patwari, the Pradhan Panch of the Panchayat, ward after adequate advance publicity. The local forest official may also be associated. During the walk, issues relating to alternative alignments, land requirements for the road, and impact on landowners will be discussed with the members of the local community present. Environmental impact on vegetation, soil, and water shall be identified for resolution. During the work, due opportunity should be given to interested persons to put forward their point of view. At the end of the work, the alignment should be finalized after recording the issues that arose during the work and the action taken / proposed To resolve the issues, this shall be reduced in writing in a document by the Secretary of the Panchayat and countersigned by the Panchayat Pradhan. A copy of this document should be attached to the finalized DPR. Now, Lordship, oh, they have filed affidavit saying that transact work was conducted. In the second case, there is item number 16. They have also annexed a copy of the transact work. But Lordship, I have filed a reply to this affidavit. We'll see that later on, but just to apprise this Honorable Court. In the transact work, the documentation regarding the transact work, Lordship, they are supposed to give the names of the person who have participated in a transact work, how many persons, the photographs of the transact work, all these things in their affidavit is totally absent, Lordship. That the copy which they have given is not even in a format, Lordship. They have given some photographs saying there is a transact work, whereas it is only a survey photo, Lordship. So that is also their Lordship. Furthermore, Lordship, my thereafter, Lordship, just I'll come back to that later on, but Annexure 6 series are my representations. These are voluminous in numbers. All of us have made representations on various.
Direct them to consider your representation, that's all. What else?
That
It's a vibrant village project. correct?
Yes.
Roads are being constructed.
yes,
Whatever, why this PMGSY? It's under, on the PMGS road.
Yes.
Under PMGS, it will.
The guidelines of PMGSY.
It should
guidelines
be
is followed.
under the PMGS.
The guidelines is followed.
No, this vibrant project,
Lordship.
road project is on the, over the PMGSY road.
Lordship.
No, these are separate and distinct projects,
Okay,
and
But-
they are following the PMGSY
Guideline.
guidelines. That's
okay.
it.
Yes.
Now, I'm intervener because I have limited.
Who are you?
I'm intervener. That's fine.
How you are, how you will be?
Lordship
allowed
is only to address if we
I'm a bidder.
Huh?
I'm a bidder.
in the NIT issued,
and I-
there were some bidders. They have come and prayed for intervening in the case. This honorable court has passed order on 28/5/24, saying that if only the question of NIT is raised, then only he can make submissions.
Therefore, that, if we wanted to vacate that, this appears to be a disputed question of fact.
No, Lordship, that is not.
The remedy
He cannot
lies-
make that submission, Lordship.
Yes.
Thank you.
Yes.
Lordship, there is something
So
I,
according to you, this NIT has been issued without following this guideline.
without taking our consent, Lordship, without taking our consent.
Consent has to be taken.
Yes,
As
they-
as per
in
the,
the-
as per the guidelines.
yes,
Okay.
because there is no mechanism for land acquisition, your Lordship has seen. They have
So
devolved
what
some
is,
kind
what
of,
is their stand?
they have filed affidavit saying that some persons have given consent and they've annexed those documents. Now, I have filed a reply affidavit pointing out one by one how these documents are flawed, Lordship. These are filled with forged signatures. In some of the documents that they have given, there are no signatures. And in one person who has purportedly signed, he was expired in 2012. So many such things. I have given in detail, Lordship, in the affidavit in reply.
See, you have to get the land from them.
My
Right?
lord, let me
There is
clarify.
no provision of acquisition.
No
If
acquisition.
you want to get the land from the, I mean, you will have to acquire the land from without payment of compensation.
In the form of donation.
Yes, you have to,
No, entire process, we have done it. Well, it is,
no, according to them, you have, it's not, you have not properly done it.
no, that is their allegation. Actually, we are coming to that.
Yes.
My lord, their allegation is that their land has been acquired without their consent. And they are talking about a transit work. If their land is taken over without their consent, then how they are concerned about a transit work? Otherwise, transit work also done. There was a meeting.
There is
And,
no proper document of transaction. I would like to point it out.
Conference.
At two.
Okay.
We'll have to dispose of this.
Yes.
Is it for
It's
this?
urgent matter.
Urgency is there.
Urgent, already tender
In
plotted.
that case, we'll take up the bail hearing first.
Obliged.
We'll take it up then. Bail hearing at 2.
बेल को बुलाएगा ना बेल बेल एक ही बार बेल को हम जाना पड़ेगा
We said list after week. Before that, don't repeat it. Yes, you have admitted that you have illegally appointed them.
so then that's a case for departmental proceedings matter
You are,
468
you have-
471 does not come in
you have retired.
I can be proceeded my lord in any case my lord right now I'm in ICU
Only on that ground. ICU.
yes
What is the
in fact
anything?
they may
He has admitted.
Yes,
So
my
far
lord.
the appointment is concerned, it was, yes, was
In
illegally.
fact,
appointed.
in
my
fact,
lord,
here he has appointed his
Just
wife,
point out in the
son,
first
daughter,
half.
three of them.
Maybe.
Huh?
Maybe if I've admitted my wife, son, I've been infected.
Yes.
That is a case for my lord. PCA, how does it apply?
No, he has, why not? PCA?
Anything,
How?
anything?
Section 8,
Yes.
he is, misuse his position.
Huh?
Now, my elder brother is asking how the PCA is attracted. Section 8 is very
No,
clear.
section 13 they have applied. Not 8.
Is there anything?
My lord.
Is there anything in there?
CD, as my lord has said, my lord, he has said that he has appointed his wife,
Wife
daughter,
also.
and son. And in fact, he has tried to,
Oh, maybe right, in that case, even if illegality is there, he has admitted the illegalities, but, there is a PCA.
yes, my lord. My lord,
Offense under PC.
our concern is that, my lord, in fact, during the course of the investigation, my lord, he has tried to tamper with the evidences, my lord. In fact, it has been reflected in CD, my lord. That is the only
Have you not
concern, my lord.
seized the documents?
We have seen, there is one of the aspect, my lord. He has illegally appointed them, my lord. But that document ought to have been seized from the office, my lord. But when we made a raid, my lord, those documents were seized from the LS accused person, my lord. Meaning that might have been already tampered with. It was found from his possession, my lord, which ought to have not been.
If it's already tempered,
No, not all the documents, my lord. In total, my lord, there are 20 illegally appointed persons, and another 8 is on the fray now.
what is your, the grounds, what is the grounds of objection?
Yes, my lord. My lord, kindly come to page 81, my lord. Maybe additional. Yes, ma'am. 89, my lord, is there.
89.
89, my lord. Starts from 89, my lord. My lord will kindly pay 90. There are 6, 8, 13 and 14, my lord.
That's good.
We are more concerned with para 14, my lord. My lord, peruse the para 14, my lord.
It's a initial stage.
Yes, Lord.
It clearly indicates, as you have said, as you have also admitted, there are certain things to be recovered also.
I'm not aware of the, I'm not aware of the.
Because, my lord,
What I'm submitting, my lord.
Yes,
Right now, I'm in ICU.
yes.
On medical ground also, my lord, because even 2022, I had an heart operation. And even before the filing of the application, I was advised to go for surgery. I went actually the last year. In between the pregnancy, my lord, I have suffered a minor stroke and I'm in ICU. I filed an additional application.
Additional paper.
Yes. Even in the main application also, the last page, there was already advice for valve replacement at page 25 in the main application. We had already an operation in 2022. We was referred to Apollo for aortic valve replacement. And during the pregnancy, my lord, now on 6, located in the ICU. That is in the additional affidavit, page 8.
And what's
Pass. I'll pass the order. Let me
As far
apply.
as my learned friend is concerned,
Hmm.
they are the employees who made the complaint. Their grievances are met. Everybody is terminated.
Lordship, I am appearing on behalf of the complainant. Only our grievances is that, Lordship, since we are, that's schedule stuff and contingency, they are 20, 30 years, they are running their, that's job in that particular department. But this accused person has Lordship. Without Lordship.
That is
Your
not-
pardon, Lordship.
Do I,
I mean,
do I require to hear you?
Lordship,
Do I need to hear you?
you know, Lordship, we are the informant, Lordship. We filed the complaint before.
Doesn't matter. Only your role is limited to assist the
Hmm.
PP. That's
my
all.
lord, only our concern is that, my lord, initially there were 20 illegal appointees. But during the course of investigation, my lord, it has been found that there are another 8, my lord. And we apprehended there are many more, my lord.
I've seen it. I'll pass the order.
My lord, I will
My-
also-
And my lord will again consider, my lord, since he is in the IAU, my lord, but then I don't think the SSC is heartless, my lord. Will pick up a person who is in the ICU, my lord.
Then you assured that. You
Because
assured that.
if he's in the ICU, my lord, obviously he cannot be arrested, my lord. Because the person when he's arrested, he will be taken for medical examination, my lord. If he's not fit, he will not be taken. Therefore, my
I'm
lord,
not
that may be
privy
considered.
to the, but SIC may not be heartless, but they are surely discriminated. We have seen what the SIC is all about. Let us not talk about it. My lord, it is a case of illegal appointment. My lord will see why the customer interrogation is required. That's all.
Obliged.
Obliged.
My lord, the petitioner in this case, so CD you may produce, I'll make my submission.
Can I take up this matter?
My lord, I'm not aware, I have not been told anything.
What do you say?
It can be taken up, my lord.
If you have no
I'm
problem,
not objecting.
you have no problem.
No,
no
I have not been told anything, so I'm not familiar. I just know the,
No, if he doesn't have, if he
That's
doesn't have.
No, I don't have.
AP has no issue, my lord. Then in any case, my lord is above all considerations.
Yes.
Now, my lord, petitioner in this case, my lord was appointed as, not appointed, but posted as Deputy Director School Education in the Lohit district. We are concerned with the Lohit in this case because the concerned accused, because these are all illegal appointments, concerned accused was posted to Lohit during his tenure. So, my lord, the petitioner came to Lohit on 5th August 2022 and he retired on 31st May 2024. He is already retired. Before retirement, my lord, interim bail application was moved. There is an interim bail. As per the direction of the Honorable Court, he was to appear on 5th of June. He appeared on 5th of June, and prior to that, his statement was also recorded. But there are certain significant aspects that I will highlight. Now, my lord, as per the FIR, total 4 teachers have been named over there who came to Lohit district during his tenure. Now, my lord, what is to be seen is, among those 4 teachers, accused 1 to accused 4, these teachers, my lord, were appointed, they were regularized on 2nd November 2020, regularized by the order of Director Elementary Education. It is nobody's case that I appointed them.
Regularized on?
2nd November 2020.
Yes.
The 4 teachers. Then, my lord, they were transferred, my lord, to 24th May 2021. From,
Yes.
my lord, after regularization, they were posted at Longding, and from Longding, they were transferred, my lord, on 24th May 2021.
Yes.
Thereafter, my lord, pursuant to that very order of transfer, it became effective, my lord, only in October 2022, they joined in Lohit district. So, my lord, in October 2022, when they joined in Lohit district, I happened to be DDSC. Now, my lord, I asked myself, what is my fault?
2023.
Yes, 2022, my lord.
22.
At that time, my lord, I was there because on 5th August 2022, I had come to Lohit district at DDSC. During my tenure, they joined. Now, my lord, they joined on transfer. They were regularized way back on 2nd November 2020. Number 1, I am not in selection committee. Number 2, I did not issue the appointment order. Number 3, they continued working those teachers. During my tenure, on the strength of an official order, they come and report to my district. You know, I am helpless. Then tomorrow I would be accused of dereliction of duty. I am not supposed to know anything. I allowed them since there was an official order. This is in respect of the 4 teachers. Now, my lord, I was told there is a 5th one also. I don't know because information keeps on coming. So far as the 5th accused is concerned, my lord, in the case of the 5th one, the order of appointment is 20th July 20th July 2022. It is again the order of Director Elementary Education. I am not the person. Now, my lord, this teacher kept on working, number 5, and he was forwarded. The order of appointment was forwarded on 6th March 23. Lord, you will see page 51. Page 51.
Yes.
This is forwarding. Forwarding of appointment letter in such and such TGT for acceptance of a joining letter who were kept under subject to submission of document during DPC held on 6/5/22. It is 6 March 23 is the forwarding.
All 4 of them are TGT.
My lord, first 4 PRT, this one is TGT. Now, my lord, this particular teacher, 6th March forwarding order, 10th March joins. Now, possibly the accusation is, since my lord, the teacher, I allowed the teacher to join at my district. My lord, why should I not? Why should I not? I ask myself. Because it's an official order. I am not involved in selection process or anything. I am not the appointing authority. Now, I'm not assuming for a moment, without admitting that the order of appointment is forged. I ask myself, am I supposed to know about the forgery in the appointment order in my capacity as DDSC? Apparently, my lord, there is nothing to indicate that. So, my lord, in no way, either overtly or covertly, directly or indirectly, I am involved here. Now, my lord, I have been told, subject to correction, I do not know what CD would reveal. The allegation is I am not cooperating. Now, my lord, I do not know what is the meaning of cooperation. I have already got my statement recorded. Pursuant to the order of the Honorable Court, I reported on 5th of June. Thereafter, my lord, he could have arrested me and could have released me on bail. I was shown as not arrested, not required. So he doesn't arrest me on 5th of June. He has not called me thereafter. The question of non-cooperation doesn't arise. And my lord, apparently I am not supposed to admit anything. He can't expect me to say that I am guilty. He can't expect me to say that I have done it. Let them establish that I have done it. So therefore, my lord, this is a fit case for bail. Apparently, custodial interrogation is not required. I am out of service. It is nobody's case. I can influence the witnesses. So therefore, my lord, bail but not jail. It's apparent, my lord, open and shut case. To me personally, my lord, this is a fit case for quashing of the FIR. Because the sections that are, which are recorded over there in the FIR, prima facie do not disclose an offense thereunder, so far as the petitioner is concerned. Applies, my lord, that's all.
My lord, I think there is nothing in the CD as far as the illegal appointments are concerned, my lord. In respect to this present petitioner, my lord, whatever my learned senior has submitted, it's very true, my lord. These 4 persons, they were appointed, illegally appointed by the then DDSC of Longding, my lord, and thereafter they were transferred. But as far as the 5th one is concerned, he has forced the signature of the then director, and he joined. There is the only discrepancy which the investigation officer concerned was that why he did not inform the senior authorities.
But how do I know? That's the question. How do I know?
Yes, yes. That is what I'm.
When the teachers came to join,
Yes.
you were supposed to inform or what?
No, but that is what they are submitting, my lord, because the statement, his statement reveals that he didn't know until they were terminated. Because they were already, they have already joined, and their service books were already opened in the other districts, my lord. So they were transferred, so he accepted that. That is the only thing. So he was supposed to be a little bit vigilant. That is what the CD reveals, my lord.
My lord, honestly, I have submit. Had I been in the place of DDSE, I would have done exactly what DDSE did. There is no way I can know these things.
That is here. And there is the statement of the then DDSC Longding. He has categorically, he has admitted that he has given no appointment.
Longding.
Yes. If my lord turns to page, I mean, of the CD, my lord. CD.
Page.
One minute, my lord. I'll just. Yeah, 49, my lord.
49.
He was the then DDSC Longding, my lord. Yes, admitted that he has given all those appointments, my lord.
No.
Yeah.
Where it is?
Nine or 10 below, lines below. Sentence, my lord.
He has admitted only two of them
Two of them,
out
but
of
the,
five.
yes, why because, my lord, he has, these two of them are his relatives, my lord. But the other two was also illegally appointed by him in connivance with the director, the then director, and one of the broker was the brother of the then education minister. My lord. There's the issue. So their service books were opened in Long Beach, and then they were transferred to Lahore. And the other one, his statement is also here, my lord. He forced the signature, but he did not join because by the time this all this case came into frame. My lord. I don't have
Mr. P.K. Tiwari, Learned Counsel, Learned Senior Counsel, assisted by Mr. K. Saxena, Learned Counsel for the accused applicant. Also on Mr. O. Pada, Learned Special PP for SIC within bracket BAG. Bracket course. This is an application under section 430 CRPC, 1970, for the grant of privilege of pre-arrest bail to the accused applicant in connection with SIG within bracket BAG, was posted so and so, read with PCX so and so, which has been registered on the basis of the report submitted by Director Elementary Education, Colonel Quite letter dated 10/01/2024. Next one. Pursuant to the submission of the report dated 10/01/2024. By the Director of Elementary Education, Goodmanabad, Madhya Pradesh. A case was registered how many cases? Will not think among others.
So far as the petition is concerned, there is only one.
my lord,
In this case, in the entire thing, on the
13.
basis of report, 13.
13, in the entire 13 affairs were filed.
13 effort was registered.
This is,
Same section.
yes, ma'am. This is pertaining to only Lohit district.
It's okay. By the SIC, being SIC, within bracket BIG, bracket close, PS case. By the SIC, vigilance, wisdom. In the present case, in respect of Lohit district, a case being SIC business PS case number 05 of 2024. under section 120, 420, 468, 471, 409. Read with section 13 within bracket 2, bracket clause of EC Act. The accused applicant was posted as Deputy Director, School Education at Lohit, apprehending arrest in connection with the above said case. Has filed this bail application for grant of bail in the events of arrest, in the event of his arrest in the aforesaid case. We'll go for shortcut because it's not been opposed on the basis of there's no material against him.
Yes, yes.
Mr. PK Tiwari, Senior Counsel, submits that the petitioner was posted when you just give me the
Fifth, my lord, he was posted at
Posted
on
as-
5th August,
as DDSC,
5th August 2022.
0508 to 2022
Retired on 31st May.
at Longding,
From there,
and
itself.
now he has been retired
No,
from service on 31,
my lord, 31st May 2022.
31st 05, 31, 05, 2024.
My lord, Lohit.
From-
These teachers came from Longding,
Yes, yes.
but he
I'll-
retired
I'll
from
record
Lohit.
that. The case relates to illegal appointments of the trained graduate teachers as well as primary teachers in the state district. In the instant case, the case particularly relates to appointment of 5 primary teachers and
4 primary teachers,
four primary
5th one
teachers
TGT.
and 1 trained graduate teachers. Mr. He submits that 4 teachers were appointed on
Appointed.
02/11/2020
Yes.
and the 5th and one teacher's TGT was appointed on 24/05/2021.
20th July 2022, 5th one, 20th, 20,
5th one,
5th one,
yes,
20th July 22.
28/07/2022.
Yes.
They were all appointed in the, under the district, under the deputy DDSC of Longding district. An appointment order issued by the director.
Yes, Director Elementary Education.
The appointment orders were issued by the Director of Elementary Education, Government of Arunachal Pradesh. Thereafter, the above 5 teachers were posted to Lohit district when the applicant was posted. Mr. On being posted at Lohit district, the teachers have joined and accordingly, the applicant being the competent authorities to accept the joining report on being transferred has accepted their joining report. He submits that other than that, the applicant is neither a member of the selection committee nor issued any appointment order, or those teachers not appointed not in the district of Lohit. Therefore, he submits that on the face of the FIR as well as the facts, there is no case has been established at all against the applicant. It's rephrased for grant of free arrest bail to the applicant accused applicant. Mr. Opada, Learned additional learned special PP for SIC business. While referring to the case diary, fairly submits that there is no materials against the accused applicant in the present case. That's all. You have no objection.
Because I don't find anything in the CD.
That's why I said fairly submits that there is no material against the accused applicant. That's all. However, since the investigation is in the initial stage, no, that cannot be. That will be contradictory again. In the CD, they have afraid for not to grant you a bail.
There was
Only on the ground that.
in fact, my lord, I have suggested that you go for quashing of the FIR itself. Vis-a-vis the petitioner. There is no case against him.
Then in that case, we'll just stop there. Only that there's no materials. Listen, next one. And consider the submission of the learned counsel for the parties and also where is the case there? Next one. Undisputably, the applicant accused applicant was posted as DDSC at Lohit, DDSC of Lohit district.
During the period 5th August 2022 to 31st of May
During
2024 when it
period from August 2022 to 31st
May 2024.
05/2024. The records clearly reveals that the teachers, at least two, have been appointed illegally, were on in the year 2020, particularly on 02/11/2022, and other one is 28/20/07/2022.
Yes.
In the district of Longding. Thereafter, these teachers were posted to Lohit district, where the applicant was serving as all were posted in 2022, in the year 2022,
Yes, all of them.
while
were
the
put-
applicant accused was.
Except the number 5, my lord. The number 5, the forwarding of the posting order was on 6th March 23. in the case of number 5,
Okay.
TGT.
In the year 2022. Except the one TGT, one trained graduate teachers was posted. Posted on which date? That fifth one?
Post, the order of posting is in respect of accused number 5, that is TGT. 20th July 22 is an appointment letter. Forwarding of the order on 6th March 23 and joining is 10th March 23 at Lohit
Okay,
when he was
posted and-
there.
Posted and joined on 10th March.
10th March.
10/03/2023. Mr. It is also revealed, it is seen that it is noticed that on being transferred of those teachers, the accused applicant has accepted the post transfer and posting order of those teachers as a competent authority. Mr. There is nothing on record to show that he is anyway connected with the appointment, illegal appointments of those teachers. Considering the above. Mr. Next matter, having considered the above. Above the considered view that the accused applicant is prima facie not connected or involved in the present in the above case. Mr. Accordingly, I deem it appropriate to grant privilege of pre-arrest bail to the accused applicant. Mr. Accordingly. The privilege of pre-arrest bail is extended to the applicant accused namely Sri Ito Ather. And
Now the
By
principle is
providing-
bail is, once the bail is made absolute, it cannot be limited to a particular period. That is till the framing of the charge.
we'll
It
just say,
continues.
we'll make it absolute.
Yeah, that's it.
Or
It
should we
continues.
pass differently? Because you have
No,
not
no,
been,
it's
you
we
have not been arrested and released on bail.
Yes. We have not been, I have not been arrested. So.
So
I
there's no
have
question of, making it absolute. We'll just pass press
No,
order.
it should be made absolute, not because there is no material whatsoever.
Okay.
And it is not their case that I need it.
Then in this case, extended to the so and so, in connection with this so and so. The bill, interim bill granted on 29/05/2024 is hereby made absolute.
Yes, that's.
With the same, what comes?
Once it is absolute, because now the law laid down by the Supreme Court is, earlier the concept was that when the charges are framed, at that stage, one was required to again take a bail. That is no longer the law.
No, when we make it absolute, should we not put on any condition?
Yes. Conditions may be put, certainly.
On the following conditions.
The earlier condition can be put.
Huh?
The condition which was given.
No, that was different, because you are supposed to appear on certain date, fixed date. On the following condition, the applicant shall appear before the investigating officer as and when called for. Then same, treat those conditions.
Only one request, my lord, that part, my lord, since my part was not been recorded properly, my lord, I would rather.
I say it fairly submits that there is no material against the accused person.
Material, my lord, but a little bit,
We'll
my
say
lord.
that, and that fairly submits that there is no prima facie materials
However,
against
since,
the.
But he opposed. This is what he wants. However, he opposed. Granting of bail.
However, my lord, since the investigation is in.
Then I said, however, he vehemently opposed the grant of bail to the accused person. No, that is what I had recorded. I wanted to record, but it's contradictory. I will use the word fair. And then when he vehemently opposed, it's contradict himself.
Therefore, my lord, cannot be said there may not be any case, my lord, but is it?
Please stop, fairly submits that there is a privacy, no, there is no privacy, there is no materials in his submission, against the accused applicant. Please, however,
The investigation being in a very initial stage, my lord, we never know, my lord.
the investigation being in the nascent stage, he has vehemently opposed the release of the accused person for grant of pre-arrest bail to the accused applicant.
Obliged.
Lord, I must admit that public prosecutors here in Itanagar bench are far more fair and impartial than is the case in Guwahati. In Guwahati, even if there is no material, they will try to manufacture something.
Yes.
This should not be done, but unfortunately, that is the case there.
My lord, item number 18, my lord. Will my lord be declaring the CV, my lord?
Yes, yes.
Judgment has been reserved.
On the basis of only will this point. Orders would, No, I'll pass it. We'll pass the order in the chamber. I'll just go through the CV. That first one, item.
Item 18. Obligement.
No, we'll finish that order first. We'll finish the order first. Ever service report in respect of respondent 2 and 3, list after 4 weeks.
Yes, Lordship, we have
Yes.
received the paper book and the matter may be fixed for the hearing next day.
Not Mr. MS,
Dirilu,
London Council for the appellant.
petition, yes.
Has it been, it is criminal appeal.
Yes,
Let's go. Hearing, already admitted.
much of it.
Where's the PP? All the PP. Legal aid counsel is not appearing since. On what a number of occasions.
Lordship,
Where is Miss MS Jeram, Hinti Jeram? She has been appointed as legal aid counsel and she has not been appearing.
yes, Lordship.
She has not been appearing since last many occasions. And she was supposed to file a petition for condemnation.
Yes, Lordship.
You inform her,
Lordship,
otherwise we'll appoint some other legal aid counsel.
Lordship.
the legal aid counsel appointed in this petition, in this matter, has not been appearing. And there's no, Mr. The council has to file an application for condemnation of delay. Today also, learned legal aid counsel remains absent. MSL, now again, learned additional PP is present and is requested, Mr. The learned additional PP is requested to inform the legal aid counsel. Just after 2 weeks.
Lordship, in item number 21, Lordship, step is not been completed, Lordship. Victim is not been, Lordship, complete, Lordship.
22,
21, Lordship.
21.
Lordship, paperwork is there, Lordship, but the service for victim number, for respondent of Lordship is still awaited.
20 or 21?
21, Lordship. 21
21?
audit, yes, Lordship.
She said it is for hearing.
Actually, I have got through the record, Lordship. The respond number 2, Lordship, the victim is, service is still awaited, Lordship.
Lordship, we have already received. We have already received the copy.
You are for respondent number 2,
No, I am for a petitioner. We have already received the paperwork.
not paper book, notice to 3 weeks,
17th of July.
3 weeks, 4 weeks.
Interim may be continued.
Interim order first, earlier shall continue.
Unless-
Is there any interim order?
Yes, Your
Interim order first, earlier shall continue. 24 also.
Lordship, this, I'm for the petitioner, Lordship.
Yes.
This matter may be list after vacation.
Hmm?
This matter may be list after vacation, Lordship.
Why?
Leading counsel, Mr. L. Parmi is having some personal difficulty.
What is the matter?
Lordship, this application is for setting and quashing the advertisement dated 28/8/2021.
Yes. What happened? Hmm? It's 26, 24.
24. 24 is Lordship, just, we want.
No, what happened? It's of 2021. They are challenging the advertisement.
Yes.
No, yes, advertisement for working in interview.
As of now, Lordship, what will be the status? I have to.
Have you filed the affidavit?
Yes.
What is your stand?
Yes, till this regular process, the selection is done.
So you have.
We
you-
just wanted to fill up.
You have appointed.
No, not happened. This advertisement is for the contextual loss for particular period of 6
You
months.
never know. That is the reason they are coming against that.
Loss. Our
It's an eyewash.
maybe
Stepping stone for appointing your own people and then for regularization.
Lordship,
Because it's not permitted, nowadays you are not permitted to conduct the recruitment rule.
Lordship,
It
that
is to
is-
be either the APPSC or the Public Service Commission or the Staff Selection Board,
Lordship.
or the
Yeah.
post.
Here, Lordship, we have written, Lordship, we have given statement, Lordship. This post, Lordship, to
It was
APSC.
for 6 years, 6 months. That is
Yes.
the reason I wanted to know whether they are continuing or not,
No, they
whether
were-
you have appointed or not.
No, they were not appointed, Lordship. This advertisement has been challenged here.
Yes,
So
In terms of the advancement, since stay is there, Lordship, no selection was done.
Okay, don't matter become influxes. You cannot do it now.
Lordship,
You have issued the advertisement
no,
at
correct.
that point of time,
Lordship.
2021,
No,
for 6 months.
for 6 months.
What
And then-
remains there?
And that Lordship, the advancement itself has been stayed by this honorable body.
Therefore, now you cannot, even if we dismiss the writ petition,
Lordship.
you cannot, because you want to appoint them for 6 months, that point of time.
Correct, Lordship. And
So we'll dispose of
Yeah,
having been influxes.
Lordship, optional Lordship, our statement.
Yes.
Till the regular selection is done.
Hmm.
Because we have written to the APSSB and APCS laws to get it repeated laws. Till that is done, Lordship, manpower is required and we want to fill.
That point of time, now in 2024,
Correct, Lordship. Now, as of today, Lordship, whether
you
those
take this, then get the status.
laws.
Forget about the stay.
No.
Obviously, you have not appointed because there is a stay.
Still.
Now, that point of time, you wanted to appoint for 6 months
6 months.
because of now, after 3 years or 2 years,
Lordship.
would you like to do the same thing?
Lordship. Then I'll take instruction, Lordship.
Tomorrow, day after tomorrow, we'll come dispose it day after tomorrow.
Friday, Lordship.
Yes.
Friday.
Only on that point.
Correct.
Even if you want to do it, will not allow you to do it. Because you have sent the requisition to the concerned selection board.
It has been said, Lord.
If you have not sent it, that's all.
So here we have, our case is very limited, Lord. Till that is completed, Lord.
That's what I'm saying. That point of time,
Correct, Lord.
you wanted. Now it's been 2 years.
Okay, let me.
Heard Mr. So-and-so, then counsel for the petitioner. Also heard Mr. Estafin Lana, senior government advocate for the state response. Come on. Considering that the challenge made in this petition is to the advertisement for working interview for appointment of junior engineer, or for filling up of the post of junior engineers, surveyor, and what else? Surveyor and
Junior estimator. Junior estimator.
Junior estimator.
estimator,
Yes.
junior estimator on contractual basis for a period of 6 months. When advertisement that is
20 August 2020.
20 August 2008 2021.
21.
Come on. The learned senior government advocate is directed to obtain instruction as to the status of the as to the status from the department concerned. It is also noticed that the posts are to be filled up through Arunachal Pradesh Public Service Commission and Arunachal Pradesh State Selection Board. Listing matter on 14/06/2020. We'll close that.
No.
If you want to proceed, also will not allow. Yes.
Lordship, this matter may be taken up after vacation.
Hmm?
Matter may be taken up after vacation, Lordship.
When?
After vacation.
Why? Have you disposed of his appeal?
Pending.
You dispose of that, that's all.
It can. In paragraph 13 also. We admitted notice for appeal is has been filed and it is pending.
Or Mr. We'll dispose it of the matter. We'll go, we'll direct the deputy commissioner to dispose of your appeal. All right.
The lordship. Maybe on next.
Problem is he challenging the eviction notice? That it is. Yes.
Password is set.
So against that, he has filed an appeal. Okay, which is pending. Or Mr. What's your name?
S. Sirang.
Yes, Sirang.
Yes.
We're disposing of. You go back. We'll direct them to dispose of the appeal. 52.
We have the same order.
This order is under section?
First section, 5. Appeal is basically in under section 12. And
No, therefore in person subsection 2 of section 6, let us see section 6. Where an appeal lies, the Arunachal Code, volume 8 or volume 7. Arunachal Pradesh Public Premises Act 2003. And also heard Mr. Esther Pinklan's senior government advocate for the status policy.
Yeah, no, see the order. Impute order is referring to not a part under section 4 and 6. And also see the section 12.
There is no provision. No appeal can lie, would lie.
Under section 12, 5, 7 and 8, order pass under 5, 7 and 8.
Yes. So what is to be done? So no appeal lies.
So on merit it may be discussed whether it's
There is no ground. These are the problem. They are not challenging it. In fact, they are filing this in the garb of challenging that eviction order, but there's nothing on the writ petition. They are not saying that the state officer doesn't have an authority. What's only the ground is, it is only on the basis of the complaint by the private party. And his land allotment application has not been considered. I have constructed the building way back. That's all. There is no challenge to the eviction, this order, impugn order, in fact. And he's saying that there are so many matters pending, and he has been singled out, similar matters. This cannot be ground to
No.
challenge.
Those processes, because they have not been made as a party also. And that cannot be.
Because of him only, I just don't want to dismiss the petition.
कल होगा
Who is your senior?
Leasing permit.
कल होगा
Where is? Can he come? Can he appear tomorrow? No,
Day after tomorrow.
day after tomorrow. These are the methods, unnecessary ways to keep it pending. There's no complicated issues involved. On the prayer of Mr. So-and-so, learned counsel appearing for Mr. L. Perma, list this matter on 14/6/2024. You tell him that we'll be disposing it off. Dismissing the writ petition. All right?
And you have next.
Yes.
In addition to what I had stated before,
Yes.
there's some things which I would like to,
You recapitulate.
just one
I
thing.
was diverted to other cases
All right, Lordship.
in a nutshell.
Lordship, I just want to show only one document, Lordship.
That I've seen it,
No, this is document, 147.
147.
Yes. We have filed complaints saying that we are not giving consent. Then on receipt of that complaint,
Your
DC,
challenge is to the NIT.
yes, NIT is saying that if you have not taken consent from us, how can you issue an NIT
NIT.
for
The land
yeah.
belongs to you.
Yes.
Okay.
So basing on that, after complaints were made, in Annexure 8, page 147,
147.
yes,
Yes.
the Deputy Commissioner of that district, Kurungkume, has written to the Executive Engineer, RWT, saying that regarding multiple complaints pertaining to Vibrant Village projects in Kurungkume district. This office has received 50 complaints from AGRIP, wherein it has been stated guidelines by secretary has not been issued by the secretary has not been followed during the land acquisition for VVWP. The actual and true owners of the land have not been taken into confidence during the process with grievance that the due process were not followed. Therefore, you are hereby directed to furnish detailed explanation in this matter to the office of the undersigned on or before 2/4/2024. In view of the ongoing simultaneous elections, you are also hereby directed to ensure that the guidelines of MCC are meticulously followed. After this letter also, so far my instruction goes, no explanations were given. That is what I would like to point out. Otherwise, reply, I have lots to point out. In reply, I have lots to point out. Let him come first.
My lord, before going to the point, I would like to apprise that this project is a flagship project launched by the government, sponsored by the government of India in the border area bordering to China. With sole objective to connect even a single house with all weather roads in order to counter the Chinese expansions. So with these objectives, the road project has been sanctioned. So before sanctioning, DPR was prepared. These are the volume, and the basic allegation is that there was no transit work. Their consent was not taken. The land was not acquired. That is their accusation. So there is altogether 20 projects, which is under challenge.
24.
20. 21 projects put to challenge in this writ petition.
21.
Yes, there is 2 writ petition. One is, in one there is 4 project and another there is 17.
Okay. Which one is 17? In the first one? 171.
170.
171,
17
21
projects.
21. No, there is no 70 project. It's wrong there.
Oh, 170.
26.
Other, all the issues are same in the both writ petitions. Now all these writ petitions, the transaction work was carried out, and Chinese wise, they have prepared whose land it is, whether it's community land. If it is community, the community land, then the villager of that community, they agree to donate the land. Then GPC of that village, Jilla Parishad member of that segment, they are the signatories. They countersign the land donation documents, and it was duly executed before the executive magistrate at coloring. And MOU was signed, donation agreement was signed. Entire process was carried out. And this is the documents. In one of the affidavit opposition, I have, where there is only three projects, I have annexed all the document. But this is very voluminous. So I did not annex the transact work. but land donation agreement is annexed here with. Now the issue is
Where it is?
my affidavit in opposition, right from page 30.
Running page.
Yes, annexure 3.
Page 30.
Hmm.
30.
Yes, 30. This is land donation agreement.
Yes.
Then after that, continuity, there is altogether in this project, 11 people they signed, which include public Gram Panchayat member,
11 what?
11 villagers they signed. GBs, GPM, whose land passes, these are the land affected people. Otherwise, all the community lands, within the community lands where the alignment pass, there happen to be some gardens or field. So these people, they have signed. They have donated the lands, and this agreement,
Yes.
there was memorandum of understanding which was signed before, counter-signed by Jila Parishad member of that area. So entire process was followed. Now the tender has been already plotted because of the stay order in this case. The further process could not be taken place. Otherwise, now my learned friend has, just before she has pointed out that there are more than 100 complaints before the DC. This all happens, my lord, just before election. This is nothing but all politically motivated petitions. Just before election, one party, other party, one party wants the tender to be plotted before election, then other party want not, tender should not be issued before election. And because of that, the
They
support.
will fix it day after tomorrow. Because, no.
Well,
Lighterman have said, he said, it's because of election only. Now election is over.
Yes.
So.
He
the
cannot
government-
submit it without
government-
any
let the-
substantiation.
let
Where
the-
does he have the proof
See,
that?
let the government, let government be formed, then things might have cooled down. So we'll go with the shortcut where.
No, otherwise also, my lord, that is my out of
In that
document
case,
submission.
it may be
Otherwise also,
clarification.
the document which they have, allegation which they have put, challenge before this, that process has been done. So thereby there is no case.
No, I will point out
So
one by
if
one.
there is any minor effect on the land of the someone's land, that has been always taken care by the officers and the contractor who execute the road. It happens. Even myself have a practical experience about that.
Yes.
While executing some work, someone's land is affected, we used to compensate by giving some control. That is always there. Even in our affidavit, we have mentioned it. Otherwise also,
In fact, your main grievance is, the
Yeah.
hidden grievance
Hmm.
is they ready to redress your hidden grievance.
it is always
According to
there.
him.
That is not my instruction. Joseph.
Otherwise,
That is really not
this-
my instruction.
this petition is a hurdle for the development activities. My lord is well aware of that the road construction is also essential infrastructure development, and moreover, this is international borders. It's a matter of national security also. So we are hearing every day in the news, TV channel, Chinese are building a village within the territory of Arunachal Pradesh. With all these objectives, these all projects are being implemented. After this road construction, Then they will construct a village, they will build a village, schools. It will keep on coming, vibrant village project. And otherwise also, my lord, in case of tender process, NG projects, my lord, is well about the NG project versus Vinod Kumar Jain. In a tender process, normally interference of court has to be very limited. Unless there is some gross illegalities involved by the authorities.
So according to you, lands have been donated by the people of the area?
Area.
Not, they are not.
Now they
are
said
not
that
the owner of the land.
now they said
The
it's
project are to be set up.
yeah. Now they are said that
I mean executed.
these roads, it's some length, some of the road length only about 5 kilometers, some are around 3 kilometers, some are 10. Only highest is 30 kilometer IT. This is all small stretch of road to connect the, even one, if there is one house, it has to be connected. This is the basic objective of it. Then now it's become, if they said it's then it's matter disputed question of facts, which this court cannot, if they have really grievances, they can claim damages from the civil court. They cannot keep on install these developmental projects. The petitioner have alternative remedies if their land is really damages. If it is not taken care of, then they can go for claim.
Is it your stand that these petitioners are not the landowners? The landowners have already donated.
Yes, they have.
They
Some
have
people
not
who-
mentioned anywhere. They have only said some people have donated.
There are at least every project, there are more than 10, 11, 16, 18 peoples there, every project.
That's what I'm saying.
So
Different.
according to you, these are the landowners.
Yes, they have, they
donated
claim
the
that
land.
it's their land and they have donated us.
But he's saying that you have not said so.
No, we have said that these people have donated the land.
He
People,
said,
are they the owners of the land?
Yes, they claim that they are the owner. Affidavit, my lord, can go through. They have written it, I am the owner. Now it's become a disputed question of facts.
Affidavit,
One second.
where it is? I'm the owner, landowner with transferable right of way.
We have clearly specific on para 13, page 8, since from page 18. Every project we have answered.
After the donation, was there any, all these agreements, donations have as per the guidelines?
Yes,
After having a meeting with the panchayat?
yes, the panchayat leaders are there, also there. Their signature are also there.
Then you need to have a MOU,
MOU with this, again, donors.
MOU with the donor.
Yes.
Okay, then you will have to, it has to be executed.
He executed before the
Through the-
executive
through the-
magistrate.
Yes. So, and then the transit work,
Yes, it was executed. Entire, within the DPR, it's all, everything is there. Since from February, it has been exercised.
why you have not annexed this?
This is my lord. Around 20 copies are there. So voluminous. Every package we have done it. This is one of the package. Alag.
Who is this man? Is the officer or the owner of the land?
Who?
This the person who is holding the placard or it's a board?
My lord, I don't have that instruction. You must.
Is it the way? It is the procedure.
Yeah, they have to identify whose land it is. Now, in there, they have explained it.
It's the only one person who is shown all along.
that's
Yes,
because
they-
that's an engineering survey. That's a survey, not transact work. I will show from my affidavit. For survey, they have to take a picture at every 100 meters. 0.01 kilometers.
My lord, transact is only to identify whose land the road is alignment is going, to identify whether this, whose land it belongs. That is the basic purpose of the transit work. So my humble submission, this matter need urgent disposal. So now already tender has been closed because of the stay order, it cannot
Where is the tender?
proceed further.
Tender is which page?
Page 54, 55. Then page 59, 60.
54.
Initially, oh, sorry, Lordship, that's, page 49, sorry. Initially, 5th February, this was the notice inviting tender. 5th February, then thereafter, it was cancelled on 7th February, that is at page 51. Thereafter again, it was floated at page 52, the lower portion. Thereafter again, a notice was issued dated 15 March 2024, the upper portion of this is page 52, saying that it has been cancelled, but government's affidavit says that it was not actually cancelled, that this was, that they had issued another corrigendum. So that is not an issue now. But we had annexed this because this was published in the newspaper. We have the copy of the newspaper also. So effectively, the tender has been issued on 13/3/24 for the second time.
50?
52
52 is?
tender, Lordship, the second tender. The same tender, it was cancelled and reissued. Page 52, the lower one,
Yes.
dated 13/3/24.
Yes.
The initial tender, which was issued on 5th February, that was cancelled and again reissued on this date.
March.
Lordship, 15 March is a cancellation order corrigendum, but they say they have not issued it, although this was published in the newspaper. They said it is not cancelled. So that is not an issue here now.
Well, let someone even try to sabotage the tender process by issuing corrigendum.
Who will issue corrigendum? It is in the newspaper.
Executive said that he have not issued that corrigendum.
This is the newspaper in which it was published. We are a simple villager.
There are so many.
We will only go by what is published in the public domain.
Then we'll consider that it has not been it has not been cancelled.
No, it has not been cancelled.
It's
Because
still-
in the website also, it is showing,
It's already.
it's showing, yes. Well, that is our,
So this cancellation will ignore.
yes.
Even
So
we
the
had-
tender will be then in that case, page 50,
Yeah, page 52,
52.
yes. The one that is issued, that will stand.
Below.
Yes, below.
bottom one,
That
bottom.
this is 13/3/24.
Okay. 13,
13/3/24.
yes.
So my lord, I'll come to the reply.
Yes.
My lord may simultaneously take up my affidavit in reply and his affidavit in opposition. The documents which he said he has annexed, that starts at page 30.
Yes.
Lordship has seen page 30.
Agreement.
Yes, agreement.
Yes.
Lordship has seen, this is actually, he says, I am the landowner with transferable right of way, 15 meters along alignment of the road. Then he says, I agree to donate portion of land throughout the proposed length. Throughout the proposed length. Now, we don't know what he means by throughout the proposed length, but because this stretch of the land is 12 kilometers. The details is in page 45 of my writ petition. Then Lordship will see the signature, page 31, his signature. Deponent, page 31.
31
Yes, the deponent, page 31
of.
of the affidavit in opposition filed by the respondents.
Yes.
Yeah, page 31.
31 is no.
There is a signature, deponent.
Yes, yes.
Lordship will see this is the same person who has signed the MOU. That starts at page 32. And the signature is at page 33. Even to the naked eye, it is visible that these signatures are not by the same person, apparently. Same person, different signature. Then Lordship will see
Which one? Which signature?
Tarba Lebo, the one at page 33, that signature. This is supposed to be the MOU signed by Tarba Lebo, and page 31 is also supposed to be signed by Tarba Lebo, who is the deponent in the affidavit. Lordship may see the signatures. Who will say this is the same person? Same signature. Then Lordship, page 33 itself, Lordship will see in the name and designation on behalf of second party, the witness signature, Engineer Nangram Bai.
How educated are you?
Who?
This Tarba Lebo.
I don't know. It is their
not a
document.
petitioner.
No, it is their document.
He's not a petitioner.
No.
Okay.
Then Lordship will see page 33. Same, page 33. In the witness column, Lordship down below, there is one Engineer Nangram Bai. Lordship has seen the signature. Nangram Bai. Then Lordship may see my affidavit in reply to this. In Annexure 1, page 27. Affidavit in reply, page 27. I have annexed some official documents of this Nangram Bai. Lordship may see the signature. Engineer Nangram Bai.
Page 27.
Yes, 27 of my affidavit in reply. Lordship will see, this is a application for leave. No, Lordship.
It's blank.
Let me see.
Page 27.
Yes.
Signature is O Dugong.
No. This is item 16.
Executing this.
Yes.
Okay. Question of fact.
You have brought the fact. I am not bringing. Page 27.
171.
Yes, 171.
Yes.
Reply.
Yes.
Page 27. Your Lordship may see side by side. Engineer Nangram Bai's signature. Page 33 of their affidavit. Page 33. That's my Lordship found. Page 33, Nangram Bai's signature, and the signature in this official document. This is a casual leave application of Nangram Bai. And also the next page, page 28 of the affidavit in reply. This is a part of DPR in which Nangarambai had signed. The left side, left portion. Apparently, even to the naked eye, this is by a different person. This is the quality of documents that they are bringing. And then Lordship. Let us, next Lordship. There are lots like this Lordship. Even in fact, some of the so-called donators have not signed in their MOUs. If I point out, it will take whole day, but let us, let us see Lordship. And then they have said that
These are the last two cases.
Lordship.
You can, all day you can hear it.
Lordship. In their affidavit, they have annexed some document in all the, behind all the MOUs. Lordship has seen the MOU. Behind all the MOUs, they have annexed some document listing some name owners, land owners, and village and signatures. Now, this is not a part of the MOU. They are saying these are, they are projecting as if this is a part of the MOU. It's a separate sheet of paper, page 34, Lordship may say. MOU is already over, witnesses signature, everything, page 33, Lordship has seen. MOU terminates in the countersign. Then there is a separate sheet of paper in which certain names are here. And in these names, page, the one at serial number 5, 6, 8, and 9 have filed affidavit saying that we have not signed any document and our documents have been forged. This I have made categorical statement and I have annexed the documents at page 29 of my affidavit in reply. 29, 30, 31, and 32. But this is actually of no consequence because it cannot be said to be part of the MOU. Even then, they file affidavit saying that we have not signed on any document. Then Lordship may see the next project, page 36. This is also one by one Sangha Tanang. Although 50 meters is written, it is actually 9 kilometers. Then Lordship will see the next page. We don't know whose signature is this because it is not legible at all, page 37.
Ultimately, there are discrepancies. Not only
Lots of discrepancies, not one
only
Lordship.
discrepancies,
Every document has it.
The documents have been forged.
Yes.
That is what you are
Definitely. Lordship may see page 38. Even the witnesses' signatures are not there. There are so many such documents, page 38. In the MOU of the second project of their affidavit, page 38. I can give a list of this, Lordship.
But then how this court will go into all these things?
No, what I'm saying is, since they are relying on these documents, saying that this land have been donated, it is their document. I'm not the one raising disputes here. It is their document. They have said we have the persons have donated land, so therefore we have done in proper process. I am saying by pointing this out, evidently it is not. At page 38, even the witnesses' signatures are not here. Not only this, every project, every document that they have annexed to project that the land documents were in proper order, it is not there at all. That opponent themselves have not signed in some documents. How can this court in such a situation come to the conclusion that they have done in a proper manner? It cannot. Also, Lordship, that affidavit, which I have filed in the next case, since they have enclosed the transact work and all, since they've enclosed some documents saying it is a transact work and all, I have made a reply. Therein, I have annexed a sample of how transact work is done. Compare that with the Transact Walk pictures which they have given. Totally different. They have not completed anything. In Transact Walk, Lordship will see in that affidavit in reply. In Transact Walk, what is done is all the persons who go, their designations name, everything is to be annexed. Pictures have to be annexed. These things are not done. The pictures they have shown are those of survey. In survey, your Lordship will notice for every 100 meters, there is to be a chainage number. Those are the documents, those are the pictures which they have annexed. And I have seen one of the booklets that they have brought. Here also it is the same thing. Can they say that they have done the Transact Walk? The Transact Walk is a very important thing because when they go through the Transact, they will decide even the alignment, whose land is here, whose is not here, how much to be taken, how much not to be taken. Without any documents showing that Transact Walk has been done, simply annexing some random documents, can they say that they have done this? That is the reason why land availability certificate was also not annexed in the DPR. That is to be done, that I have shown earlier also. Also, Lordship, very interestingly, in my affidavit in reply, in the last page, I have annexed one document. They have said they have made the countersign before the magistrate, Lordship. Now, one of my earlier lawyers had given a legal notice to the executive magistrate saying why you have countersigned. In reply, he has said that, Lordship may see the last page, that the matter concerned affidavit of land donation memorandum of understanding whereby undersigned has approved to countersign only after documents were provided and duly countersigned by executive engineer. He has not said they've appeared before him. However, after complaint received by GPC of Mili and Wabia segments that their signatures were forged, the facts and documents were submitted were cross-examined. The complainant were summoned to verify the affidavit to ascertain the correctness of the same. Claim as inquired, they have stated that the signature of affidavit for land donation and MOU was not right and might have been forged by some unscrupulous persons, individuals. This is the reply. So even that part is gone. Now, Lordship, if Lordship permits, I can go one by one to the documents that they have annexed. Every document has some fault. I say that they have forged the documents in order to just speed up everything. And then they have placed before this court and they are saying they were raising disputed questions. We are not raising disputed questions. Apparently, the documents are, interestingly, your Lordship will see, one person who has expired in 2012, even his name is there in one of the documents. I have annexed the tombstone also. This is how far they are going.
Otherwise,
my contention is, Lordship, if they have done in this manner, Lordship may go through the detail in my affidavit and reply. If they have done in this manner, they are trying to say that, okay, this is a project, this is for good for everybody. So therefore, we will just do whatever we please. It is not like that. What is preventing them from conducting a Gram Sabha and everything, Lordship? That they could have done. We have filed representations, so DC has also said, kindly do it in a proper manner. They have not done it. They have simply speed up everything. So this is not a case wherein they have proved that that we are not the owner of the land or this person is the owner of the land. No. Who are they to say whether we are owner of the land? They are not a civil court. They are not somebody who will decide. They cannot say. They are only saying on the basis of these land donation agreements, which are apparently forged. And your Lordship knows, in a hilly area like that, how many people will be having land of at least 20 kilometers at a stretch? This is not something which is usual. In some of the projects, it is 15 kilometers, some of 18, some 19, some 20 at a stretch. That is why cleverly, in the documents, they have not mentioned that this much land I am donating. Your Lordship will see in each document, they have not mentioned the portion of the land. They have not mentioned how much length of the land is there. At least they were that much clever. So my humble submission is that the NIT, although I'm not against NIT, of course, we also need road projects, but these things should be done in a proper manner. They cannot just take away our land like that. It may be so that we may not be agreeable to the alignment also. If transit work were done, if things were done, then things would fall into place. So the NIT, although I have nothing against the NIT, because it is born out of this, is wrong. They
Otherwise-
can,
Otherwise, if except for this.
Yes.
The procedure which they have not followed.
Yes.
Suppose if we assume that they have not followed, the construction will be done. The
Construction
project
will be done,
implemented.
construction may be done, but there may be a question of
Project
alignment also.
Has to be implemented.
Yes, project has to be implemented. Let them do the
You are not
process
agreed
again.
By implementation of the project. You are not agreed by the.
No, no, no,
implementation.
no, no. We also want the project should be implemented, but question may also come regarding the alignment. Suppose that is why this transit work and all are important. That is why these things are given. We may willingly give also. It is not that we never want to give our land. It is not like that. Some of us may be wanting to give, some may not wanting to give. That we cannot speak for everyone. So that alignment could be changed. So if these things are, if the NIT is cancelled and if they do the process in a proper manner, we have no objection.
And some is also the bidders, I am told.
Huh?
Some of the petitioners are also bidders. They also participate in
That
the.
I don't know. No, that's because we have
Many
nothing
things
against
are there.
NIT. But I don't have any,
it's a-
let him bring on record then. I have no,
It's okay.
No.
Now, suppose if the project is implemented
yes,
without following this procedure,
yes.
practically what would be what would be the effect or the
It would amount to,
prejudice or
it would,
how cost to you?
it would amount to taking our land forcibly, some of us at least. There may be some people who may not
Suppose
agree.
You would like to give it.
I cannot speak for everyone.
Okay, yeah.
I cannot speak for everyone.
Yes.
There may be some people who may not be agreeable to the alignment, for example.
So under this scheme,
Yes,
under the project, you cannot be forced to
yes, I cannot be forced to.
because there's no compensation.
Yes. That is why their government has sort of to make this kind of mechanism, asking for land donation and all. If there,
Is it not the case that just because of they have not followed properly minutely in minutes? So minutely they have not followed. Therefore, are you not
not
taking-
minorly, they have not followed at all.
No. For example,
Yes,
are you not trying to take make auto advantage of it?
no, not at all.
Because you want the road, you want the road should be constructed. It's beneficial for the people.
That does not mean, however, that they should construct it in any way they want. Like I said, there may be a question of alignment. There may be some land, suppose a very precious land. Suppose,
See, suppose those persons
yes,
who have given the land,
yes,
you may not be included.
yes,
If it goes through you,
Yes.
if you want to give the land,
yes.
if they make a complaint, who will decide again?
That
Because
is why,
again, they will have the same problem.
that is why they have this, they
Same
take
right
into,
as you
they
have-
take into confidence the Gram Sabha. In other places, there is not much of a problem because they conduct Gram Sabha in a proper manner.
Which district?
This is of
Kurungkume.
Kurungkume.
My lord, as of today, regarding vibrant village, first case came from Chiang Tajo.
Ah.
Then after election, they withdraw.
He's talking about election again.
Now this is second case. Then there is another case from Anjor Anini. It's still there.
In
But
that case,
in that case, there is no stay. Work is ongoing.
Then let
But in this case, practical difficulties suppose we have two brothers. If there is some common land, elder brother want to give a donation.
No,
but-
that's the reason.
uh,
These practical problems had been, there's a sense of this, such a practical problem in these areas. I mean, not particularly Arunachal, maybe.
Yeah,
some
otherwise,
other parts also.
my lord, this
Is there any, these projects are implemented in the other part of the country?
Other
part of the
districts also, I believe,
country,
yes, yes.
Not the district?
Other districts, I think.
No, other part of the country.
Oh, that I have no idea.
no PMGIS.
Jammu and Kashmir, all the international
The
borders.
government might have they might have sensed the situation.
Yes.
Therefore, these guidelines have been issued.
Yes.
So you are bound to follow the guidelines.
The guideline has been followed. Actually, regarding compensation, there is some case for PMGS road also. The government, central government has not said that totally they should not be paid. But state government can pay, but the state government have a pound crunch. So they ask donation from the affected people.
That is why.
So
they
that
should
is the
know.
procedure which is followed.
Discord is, I mean, whatever is in
Yes.
the back of the discord will not decide on the matter, decide the matter.
Yes.
Will not get influenced by that. But then it appears that you have no, your documents is also not proper.
My lord, that is again,
You
if
do it, what's wrong? If
That's
it's
what
not
I'm saying.
proper?
there is
No,
a,
you are not losing any, only time, and the time would be, I mean, you may lose the time, otherwise you are not paying anything to them.
no, that is
Have a
true.
Gram Seva, have a transit walk.
Maybe because of
get,
inexperience,
and
they have.
discuss with them. And let them understand this is for your benefit. This is not for the engineers or the department only. They are the executing agency for the benefit of the people. That is what they want. They are not claiming anything.
But from our side, we said that we have conduct all these things.
But the way he has project, he
But
has
that
shown
is
the
again,
documents.
That is
Lordship may
better to
see
be.
my affidavit in
Yeah,
reply.
May not
This-
may not come within the purview of, I mean, having a fishing and robbing inquiry. on
Yeah,
it.
that is,
But then practically it appears to be you have not done your part also. When there's a guidelines, there's a basis
yes.
and the reason for issuing issuance of a guidelines. Because these problems is there, therefore the government on its own wisdom has issued these guidelines. Is not it?
Yes, guideline is there. Even the secretary has written to them. So according to their understanding that what they have done is the right.
How
That-
long it takes to have a Gram Sabha and transit walk, what is called?
Transit walk.
And all these things.
Hmm.
You discuss with all the people, stakeholders, all the village people. Or else that you want to wait for some time, so that things will cool down. And the electricity will be disposal and will go, or you don't want to do your job.
No, they can correct that by doing all these things. Let the work be
Otherwise,
continued.
normally, these are.
How
for-
can the work be continued if the NIT has been issued,
My lord-
taking this sort of alignments?
My lord, this case out altogether.
They
there
have
are
to do everything again.
4 blocks. Coloring, Charlie, Damin, Persiparlaw. Not out of this 90 something contractor petitioners. Not that in one project entire their land is affected. If there is not admitting if there is their land any land also, only some portion of land may affected. Out of 26 projects. Some 1 or 2 land will be at Coloring, some will be at Damin, Persiparlaw, Sarli. So what I stated, in case some has been left out, if their land is affected, during the execution, if they have alternative remedies. Alternative remedies is always there.
remedy? What is the remedy?
They can always go for compensation, claim for compensation by filing suit,
No.
or they approach the authority.
Since they are not.
We don't have money to
No,
file suits.
No, not that. Under the project, they are not entitled to any compensation or damages you are saying. Why you should take that risk?
No, I am saying that otherwise.
No, by saying this, sounding like an autocrat. I can do whatever you want. You do whatever you want later on. That is not, that should not be the approach of the government.
Land itself is disputed. Someone have a donated
No,
land that is taking
there-
that there's land.
Their affidavit is disputed, not the land.
That is again matter of investigation. This court has.
When did you file this affidavit?
This morning?
Today. Have you received it?
Yes.
You are happy? Have you gone through this?
My lord, afford me 1 minute as an intervener.
No, just wait.
We are not challenging NIT. We are not saying NIT is bad. We are only saying NIT could not have been issued. So in terms of the order of this court, you cannot make any submissions.
I have been given liberty to file affidavit even.
Yes, on the ground of NIT only.
Ah.
Yes.
Well, otherwise, since they have submitted so many representation, let it be disposed of. Let the city to dispose.
If
of it.
the representation is allowed, then since the NIT has already been issued, it cannot be undone. Nothing can be undone. There is no point.
Well, not only to that tender aspect, I'll not make extra submissions.
He's not he's
I
not
haven't
against it.
submitted anything against the tenders.
The question is, my lord, I present my case in this particular manner without malice or prejudice to the right of petitioners
You should.
and the
never-
counsel
you
for the
should-
petitioners.
You never should.
Except
You never should.
here,
Why
except for a
malice and
particular,
prejudice?
because the reason for becoming intervener was for the purpose that tender process was on, we were the bidders. In fact, 5 to 15, they are all interveners and they are bidders in all these projects. Now the question comes, whether order 1 rule 5, rule 10, joinder and misjoinder of the parties was fulfilled or not. By suppressing the material fact, when the tender process was on, we were not made parties, and then interim order was obtained. That is the first thing that I want to raise, Madam. The second aspect is the state respondent and the petitioners, they have their own dispute, and that is none of my business. My concern is, my lord, let the interim order be vacated and the tender process be continued in view of the NG products and the later judgments by the Madras Alimony Company judgment. My lord. Developmental activities cannot be
What
halted.
judgment?
That NG and Madras Aluminium Company judgment. This later judgment in 2023. NG is of 2022. My lord. The developmental project, my lord, cannot be halted. So that is the core issue, my lord. So once
Normally,
normally, my lord, normally.
In not in all the cases. In not all the cases, normally.
So therefore, my lord, the project is sensitive in nature concerning the international border ramifications. In that, even is it justified to hold the entire work and also the tender process? Let tender process be continued, and they have every right to get their land protected. There are other ways around. So therefore, my lord will apply the
All these
wisdom.
projects passes through, it's on your land.
Yes.
But at the same time, my lord, I appreciate. that
Not only us,
Article
there are some other
300
people also.
Article 300A cannot be violated in this matter.
No,
A-
It's not a question of the Article 300A. It's a question of the public interest, which they also be benefited. What they are saying is simply since there is no compensation provision,
Correct.
there is a set of guidelines you have to follow, which you have not followed.
Because law provides
That's all.
you to do.
Of course, you
a
are
thing-
not you, by the state. That's
Well,
why I'm asking, what's the wrong in following your guidelines?
Well,
We have said we have followed
I conclude my
it.
submission in this manner. Ultimately, they have filed series of representations, and on record,
We'll continue day after tomorrow. We'll finish off day after on Friday, all right? Have some
I know.
important books.
Yes.
Of course, we can, time is up to 4:45.
Lordship.
Well, these need to be
But
changed because.
It's up to your lordship. I have no
No, I have
problem.
some, I'm sorry, I have some other report.
Yes, yes.
As it work. So we'll continue on, day after tomorrow.
Lordship.
Tomorrow is we're having a division bench.
Yes.
As well as so many fixed matters. So day after tomorrow. Let us see.
In
whether-
order to shorten the time, your lordship may see my affidavit in reply. My affidavit in replies.
Once we are relieved from the room, court room,
Section
we have
65,
some other things.
PO
So-
is not
Claim-
complied with, certification
counter
is
claim
required.
are there.
Some digital records have been brought
Friday,
to in the
Friday,
form
we'll
of
see.
photograph.
We'll see whether, we'll try to dispose it off, whether we'll be able to do it. Let us see. Okay.
Correct, great.
Oh, interim order may be continued then.
Let,
Tomorrow, nothing but.
yes, yes, come.
No, it's not. Well, he can note it down.
You just note it down.
Yes.
Endang, MS Endangen. You just record your name. Let the matter be listed on 14/06/2024 for further consideration. For under consideration, that's all.
Interim order to be continued.
The interim order was earlier. So
Ma'am.
Interim continue like no.
Let the
Consideration जो पहले होगा, उसके बाद interim order वाला next होगा. Till next date of this.
Let the matter be listed on 4/6/2024 for further consideration. Nah. Interim order pass earlier section. Interim order pass earlier shall continue till the next.
Yes. Yes, your question. Sí, ya que eso garum sa. No mo duma to. Mo atas ngelo sa ingin nila Boleh na. Hearing lambau ka pa siya siya. Miktere madam. Within 1 minute meno aya. Demo is the production na so. Yung pwede pansis na mga na obyo kadal nila ay. Ajo na na halo mo mla ko lo oil ne ko na mo ngok tapos ning ko na mo no na men malap if you have any work to sharing obyo na la mo mo sa malap ini ano obyo sa na ko ko sa mo to do mo ingay sa lo sa tempe mo mi ni yo ko lang tam na men hal ingay वो जो कल के लिए जो फिक्स हो जाता है ना, जैसे आज सुबह को आप दिया था ना, ऐसे वो लोग टुमारो में तक को खुद से सिस्टम से पीएसयू से ले लेते हैं ना।